welcome to all those that are following us online. Yesterday was a very powerful day. Very strong evidence was given by a lot of people, and I want to thank all those that came yesterday as witnesses and gave such well-informed and powerful statements, which will obviously be included in the report that we do and the proposals that we make at the end of all this. I want to say thank you to the team that have worked so hard to put this together, both from the Peace and Justice Project and my own office, and of course from the many volunteers who've done so much to help us yesterday and today. Over 20,000 people were following us online yesterday, and we will be putting together a video report of the whole 2 days, which again will obviously be very widely available. We're adopting the same pattern as yesterday, where we'll introduce witnesses 3 at a time with a maximum of 15 minutes in total for each witness. That's roughly speaking 10 minutes for the statement and up to 5 minutes for questions. And I'm very grateful to all of those that gave evidence yesterday for giving very concise, very precise statements. Nearly everybody was absolutely within the 10 minutes, which helps us a great deal to keep to the timetable that we've set, because it's unfair on later witnesses if it overruns too early in the day. So the first panel this morning I want to introduce is Matt Kennard, British investigative journalist and author, co-founder and former head of Declassified UK, an outlet dedicated to in-depth reporting on British foreign policy, and also author of The Irregular Army and the Racket, who works examining global militarism and corporate power. Matt, welcome and thank you very much. I'll introduce the other 2 witnesses and then we'll start hearing from you first, Matt. Fawz Khan, a leading barrister, over 30 years experience in criminal law, recognised as highly experienced advocate and dealing with very serious and complex cases, including homicide, terrorism and fraud. He's been active in legal education, advocacy training and human rights work. And lastly, Mark Smith will be giving evidence as a British civil servant who resigned from his role in 2024 in protest of British arms sales to Israel. At the time of his resignation, he was working as a policy advisor at the Foreign, Commonwealth and Development Office, and his decision followed reports of UK manufactured arms being used in Israeli military operations in Gaza. They're all very welcome. Matt Kennard to start, please. And Matt, thank you very much for coming and giving us your time.
Thanks for having me.
Speak very close to the microphone, please.
Okay, I'll start by just saying that the title of the tribunal is an inquiry into British complicity, but I've been covering the military and intelligence support to Israel the last nearly 2 years now during the genocide, and I think I used the word complicity for a while, but having looked at the evidence and studied it and investigated it, I think it definitely crosses the line to participation. The UK government, through its different military and intelligence agency, has been a participant, and I'm going to display how now. So I've got a slideshow just to help the presentation. The first one, this is a picture of RAF Akrotiri, which is a huge airbase on Cyprus, which the UK retained when Cyprus got independence in 1960. There's also a huge intelligence station in the east of the island called Dekelia, and RAF Akrotiri became very quickly the central international site for supporting and supplying Israel's genocide in Gaza. That's a picture I took actually because I went there in 2022, and it's just to demonstrate how big it is and the security. So I went to get an interview. They wouldn't give me one, obviously, so I drove around trying to get as close as I could, and that was as close as I could get. That's a gate that leads onto the airbase, which you can see in the distance, and it says, keep out, you're not allowed to take a photo. So obviously I had to take a photo. Then that's Dekelia, which I also went to in the east of the island. Again, so we know quite a lot now about RAF Akrotiri's role. We know nothing about the intelligence role that has been done at Dekelia. And also important to say that US personnel are at both locations as well. They're both unofficially joint US-UK bases. Okay, so this is a picture early on of a military transport flight that went to Israel from Akrotiri. This is a RAF one. Now, this was in November 2023. And initially, the UK government refused to say how many RAF planes were going to Israel. So I started looking at flight tracking websites and started seeing that they were going nearly daily. Now, these are huge military transport vehicles, the A400Ms and C-17s. They can carry tanks, helicopters, all sorts of weaponry and personnel. Eventually, after my investigations, a question was asked in Parliament, and you can see how many RAF planes went. These are the huge military transport planes. Kenny McCaskill, MP, asked, and by early February 2024, 48 RAF planes had flown to Israel since the 7th of October. Now, to this day, we do not know what were on those planes. The government's been very, very reticent to say, and in fact has basically stonewalled any journalistic requests for information. As you can see, the second line in that parliamentary question says these flights have included, which is clever, transporting ministers and senior officials with diplomatic engagements. Now, I did an analysis of how many ministers had visited Israel, and it was a couple that had visited Israel. So it doesn't explain why 48 planes went. So that's an open question. Again, I started looking at the other flights and saw that the US military were also flying regularly from Akrotiri to Tel Aviv from RAF Akrotiri. Again, we knew from other reporting that these were carrying weapons, huge amounts of weapons. And in fact, at the time, early on in the genocide, Haaretz, the Israeli newspaper, said that Cyprus and RAF Akrotiri had become the international hub for supporting Israel. Then early on, so this is October 27, so soon after the genocide began, it was reported that the SAS had deployed to Cyprus. SAS are the highly secretive special forces that are run by the Ministry of Defense. And the day after that happened, the UK military sent out a D-notice. A D-notice is a censorship order sent out by the UK military and intelligence services to media. That was on the 28th. You can see the date. The day before was the story in The Sun. So since that day, since the 28th of October 2023, we have had zero information about what UK special forces have been doing in Israel and potentially Gaza. So again, a huge open question, but suggests participation on a big level, I believe. Knowing what I do about the SAS and how they operate, I imagine they definitely had an advisory role on the ground invasion and could potentially have been on the ground in Gaza. We don't know. As you can see, one of the lines in that is this notice, this censorship notice, aims to stop any information being released about special forces and other MOD units engaged in security, intelligence, and counter-terrorist operations. So basically, it's saying a blanket censorship order for all, not just special forces, but all MOD operations to support Israel. And then at this time, I also started noticing that spy flights were being sent from RAF Akrotiri, and that's a picture of one. So they announced, the British government announced in December 2023 that they were going to start spy flights over Gaza in support of Israel. They didn't say where they were going from, how long they were going to be in the air, or what plane. I found that they were going from RAF Akrotiri. They were Shadow R1s, planes whose capabilities include target acquisition for military strikes. And that's one. They were going nearly daily, and they're still going nearly daily. Actually, there's a video of one. So they always turned off their transponder over the sea, so we could never see what they were doing over Gaza. But that changed very recently, in fact, in July, because the Labour government secretly contracted out these operations to a US company called the Sierra Nevada Corporation. And this new plane, which was the same model, it's a Beechcraft King Air 350, came from the United States to RAF Akrotiri and arrived in mid-July. From 20th of July to 25th of July, it was escorted over Gaza by an RAF plane, the same RAF plane, and then started flying by itself. And the new pilot who worked for the company, the contract was for the RAF, forgot to turn off his transponder for the first time, so we knew what was going on. Now, this is the flight path, and I think this should be evidence in a war crimes trial, because the UK government, when they had to defend it, which they haven't much because the British government haven't been probed by the journalists at all, always say it's for hostage rescue. But if you look at that flight path, there was an analysis done by John Elmer at Electronic Intifada, who's kind of the leading expert in the English-speaking media on the situation on the ground. He said this looks like a surveillance overflight for Israeli military operation, because it's all around Khan Yunis, which was where all the fighting was happening at the time. The Israeli government obviously don't know where the hostages are, but they don't think they're in Khan Yunis, they think they're in northern Gaza. So this is why they were turning off their transponder. This is why they didn't want us to know what those surveillance planes were going on. Also, after this was the first time the mainstream media got interested. And in fact, an article in the Times really blew open a lot of the information we were trying to get. And this Times journalist got an MOD source to say that actually this information was being handed to the Israeli military in real time. Now, up till now, the UK government had always said, we only give the information to relevant authorities, and it'd never be specific. But now we know that they were handing it and have been handing it to the Israeli military. We know actually that they're also handing it to the Israeli military in real time, which means when the plane's in the sky. So when they say it's for hostage rescue, it's preposterous, because if you're sending this information to the Israeli military in real time, how can you then say, well, we only want you to use it for hostage rescue? Once it's in Israel's hands, they can use it for whatever they want. This indicates it's to do with the fighting on the ground as well. Just to press home how oversized the UK role has been in the surveillance of Gaza. This is an Al Jazeera investigation which was done after some of the work we were doing. And they tracked all the reconnaissance flights over Gaza and found that Britain had flown nearly half of them, 47%, which was more than double Israel itself during the genocide. So this, to me, looks like participation. This is not complicity, this is participation. Another important story which came out, which shows the oversized UK role, was in June 2024, when the New York Times published an investigation based on Israeli military sources who said that, well, you can see, I've done a box around the subtitle, it says, intelligence collection and analysis teams from the US and the UK have been in Israel throughout the war. So a UK spy team was deployed early in the genocide to Israel itself. And in that article, the Israeli official, anonymous Israeli official, says Britain's spies are providing us with value added, that's the quote, and giving us intelligence we cannot collect on our own, that's the other quote. So you can, and these are spies inside inside Israel, probably involving MI6, GCHQ, and maybe the SAS as well. We don't know if they're still there. There's never been a word written in the British media about that New York Times story. This spy team doesn't exist in the mainstream media. So again, huge level of participation, not complicity. And then this was Sunday this week. US Special Forces planes have been going from RAF Akrotiri and continue to go. So these are CN-235 planes, which are used by a highly secretive part of the US military Special Forces unit and the CIA. Again, the Labour government and the previous Conservative government have never given any information about US flights. They don't even tell us how many are going. They don't tell us about the planes. They don't say what they're carrying. So again, we don't know what they're carrying. These are going regularly at the moment, these US Special Forces planes. They land in Israel and then fly back to Akrotiri about an hour later. So they're clearly dropping something off or picking something up. Again, we don't know. I don't think I've got much time left, so I'll just finish quickly on the weapons side of things, because obviously the participation in, if you're sending large amounts of weapons. Now, the Labour government realised early on that they were probably being told by lawyers, look, you are complicit in this and you're liable to face charges. So the Labour government announced these suspensions, 29 arms license suspensions of 350 arms licenses, so about 8% in September 2024. We found, and we published a story, that actually this was essentially a lie, and it was a fraud and a farce. And in fact, from September 2024, the month that they announced those, to February 2025, they sent over 8,000 quote-unquote munitions of war to Israel, including all the most serious munitions you can think of. And we only found this out through Israeli customs data. So the image that the Labour government has tried to present, that they are not providing weapons that can be used in Gaza, is a lie. Secondly, obviously, they carved out the F-35 parts, which is one of the major bits of technology that's been used to get the genocide done. So again, doesn't make any sense. And then, sorry, I'll finish with this. This is another huge part of the participation and complicity, which is the Israeli Air Force planes that have been landing in Britain. Now, again, these aren't registered. Their takeoffs and landings aren't registered on any commercial flight tracking websites. We track them through transponder data. And we found that Israeli Air Force refueling planes that were refueling fighter jets over Gaza were landing in the UK. at RAF Bryce Norton on the way to the United States and back again. And in fact, we found in October 2024, there was a massacre in Bet Lahia, and one of these planes, they're called Ream air refueling planes, was over Bet Lahia, with, likely refueling an Israeli fighter jet that committed the war crime, which killed 73 people. That plane had been in Britain 4 days before. And I did some work on this early on in the genocide and asked the government to give me details about how many Israeli Air Force planes were landing in Britain. And they refused to do it. I independently got some information, published it, and they then said, okay, 9 have landed. This was about February 2024. As the same question was asked in Parliament again a couple of months later, and they refused to give information about it. So they changed the policy again, and now Labour is refusing to give any information about Israeli Air Force planes landing. So this is a huge area of complicity. We don't know why they're landing. Are they refueling, dropping stuff off? But anyway, if you're talking about planes that are being operated by a military whose defence minister former defence minister has an arrest warrant from the ICC, and you're allowing these planes to land in your country, then you are complicit in what is going on. So, yeah, I think.
Matt, thank you very, very much for that very powerful presentation. Questions from my colleagues? Neve.
Thank you so much. Do you have any idea of what they're trying to gather? Is it SIM cards? Is it what are they trying to do through these kind of flights over Gaza?
I think that, as I say, we didn't know what they were doing over Gaza until the July 28th, and that pilot forgot to turn off his transponder. And that evidence clearly shows, I believe, that they are involved in the military campaign. Because the fact that it was over Khan Yunis for around 2 hours, and it's circling. Now, why, if you're looking for hostages and the Israeli government itself doesn't believe they're in Khan Yunis, why are you circling the major area of fighting that is happening in Gaza? Doesn't make any sense. Secondly, as I mentioned, that Times article revealed that they're handing this intelligence to the Israeli military in real time. So the idea that it's just for hostage rescue is preposterous, doesn't make any sense. And the reason they say that is because they know that this is participation in war crimes. And you can't, even in a court of law, if you were asked, well, why were you handing all this intelligence to a power that was committing regular war crimes, and they said, oh, it's just for hostage rescue, they'd say, well, how did you ensure it was only used for hostage rescue? There's absolutely no way they can ensure that the Israelis are using it just for hostage rescue. Plus, so I think it is part of the military campaign. That's what I believe. I also believe that spy team in Israel is crucial to, the UK spy team deployed inside Israel is crucial to the whole operation, military operation. And it just goes to show, and the reason there's so much secrecy around it. The reason we've only been able to find this out is through novel journalistic techniques. There's been no disclosure from the government. It's because they know that when the verbiage, the propaganda is cleared away, it shows clear participation. They are a participant. They've done nearly half of the surveillance flights and I believe they're overflights for the Israeli military campaign. So I think they're collecting information on the ground to help Israel in their genocidal war against the Palestinians.
Just a quick question. So it seems that both American and Israeli forces are using these military bases. So is it safe to say that there isn't an American military base in Cyprus? It's only a British one.
Yeah. Yes, but so the Americans have been there for 50 years, but the UK government never said how many Americans were there. I did a story in 2022 revealing for the first time how many Americans were there. It's 129 airmen US airmen on RAF Akrotiri. In Dikelia, which is the intelligence station, that's a joint intelligence station with the Americans. Again, unofficially, the only reason we know that is because of Edward Snowden. Edward Snowden revealed that the NSA pays half of the upkeep of Dikelia. So then there's RAF Troodos, which is a huge US-UK intelligence station. It's the highest point in Cyprus through which they gather up intelligence all over North Africa and the Middle East. Again, as I mentioned, we don't know what the US and UK sites in Cyprus, the intelligence ones, have been doing to help Israel. I imagine when we do, if there is a legal process of discovery, we'll find out they were as integral to these sites, were as integral as RAF Akrotiri has been to the whole operation.
One last question from me, because we need to move on then. We heard yesterday from Professor Nikos Trimanglitios that the Cypriot military facilities have also been used by the RAF. Were you able to observe any of that during your visits to Cyprus?
No, because I focused mainly on the sovereign base areas, so I didn't go to see the Cypriot sites. But I should end with an important point, which was hinted at earlier, which is that it's possible that the Israeli Air Force itself and F-35 jets have been using RAF Akrotiri, because as we know, the UK is a key player in the F-35 global program and provides maintenance and aftercare to F-35 vehicles. One of the major places that happens is RAF Akrotiri, and there was an article in the Daily Express in 2024 saying that the British had a deal with the Israelis to use RAF Akrotiri for aftercare and maintenance. That article was sourced to senior officials in the MOD. The article was about how UK had now rescinded this access. But whether that was true and what was happening from October 2023 to February 2024, we don't know. So it's highly likely that Israeli Air Force fighter jets that have been bombing Gaza have been landing at RAF Akrotiri again as well, and we have no idea and no way of finding out because the government won't tell us. Again, huge levels of secrecy to cover up participation in genocide.
If we can include that reference in the evidence, that'd be very helpful.
Yeah,
Thank you.
yeah.
Any more questions for Matt? Matt, thank you very, very much indeed for that and for the presentation today. Pause, over to you.
Good morning. I have been asked to address the issue of whether or not Britain has fulfilled its legal obligations, both nationally and internationally. In order that I can answer that, I first set out what Britain's obligations are. Firstly, on the 11th of December of 1946, the United Nations General Assembly, by Resolution 96, Sub-Resolution 1, declared genocide to be a crime. On the 9th of December 1948, the General Assembly, by Resolution 260, adopted on the 9th of December 1948, 2 years later, the Convention on the Protection and Punishment of the Crime of Genocide. By Article 1 of that convention, Britain undertook to both prevent and punish genocide. The British government has failed in any way whatsoever to prevent Israel or to punish any IDF soldier, many of whom have taken active part in the genocide in Israel and have returned to the United Kingdom. A report has been sent to the Metropolitan Police setting out the names of those IDF soldiers, but nothing has happened. Article 8 of the Convention sets out that the UK government could have brought proceedings against Israel to both prevent and suppress any of the acts which are set out by Article 3. South Africa has led the way, other countries have followed, Britain has done nothing. Under Article 3, paragraph E, it is made plain that complicity is a crime. The dictionary definition of complicity is the fact or condition of being involved with others in an activity that is either unlawful or morally wrong. As has already been set out by previous witnesses, hardware in the form of F-35 parts, other arms, training, information and surveillance flights have been provided by way of assistance to Israel. Britain has countenanced Israel's actions in deeds in many, many ways, and that includes when there's been murder of British citizens in occupied Palestinian territories. I gave pro bono legal advice to the parents of a murdered British aid worker killed by Israel whilst in Gaza. The murder is very likely to have been recorded by one of those surveillance flights. It's already been set out that the RAF Akrotiri is used on a number of occasions, it is highly likely that the plane, having recorded that murder, returned to RAF Akrotiri, and obviously there have been more than 500 flights. The flight in question downloaded the footage. Despite us asking for it, it has not been revealed. All information gleaned by those flights has been supplied to Israel. There is no restriction on what the uses can be put to of that information. It's important to note that under Article 4, rulers of a country, public officials of a country, private individuals of a country are liable to punishment under the Convention if they are found to be complicit. Article 5, all contracting parties were to put into place legislation to give effect to the Convention, in particular, penalties for genocide. In 2001, the International Criminal Court Act was passed. Under Section 51 of that Act, genocide, crimes against humanity, and war crimes are explicitly set out and incorporated into English law. Under Section 52, conduct ancillary to genocide, which is committed outside of the jurisdiction, in other words, in Israel or Cyprus, are set out and made inculpatory. And Section 53 sets out how a trial and punishment for certain offences can take place. Under Section 53, subsection 5, the penalty where a murder has taken place is life. Where there is non-murder, the penalty is 30 years. It is highly likely that the Prime Minister of this country is guilty of genocide. It is highly likely that John Healey, the Defence Secretary, and others who provide support, some of them civil servants, often against their will be found guilty should they be tried. I was asked to give an opinion on the question of has Britain fulfilled its legal obligations. The answer is a clear no. Not only has it not fulfilled its legal obligations, the United Kingdom government has totally and utterly breached international criminal and UK criminal law and its legal obligations, as well as assisted genocide. I'm happy to answer any questions.
Questions?
So, if I understand correctly, you represent the Henderson family.
I do.
And Henderson is a British citizen that was killed in the Gaza Strip.
He was an aid worker. He went out to do some voluntary work. He was in a 4x4 vehicle. There were several vehicles partaking in the work that they do by the provision of aid, and an Israeli drone fired upon them. It is highly likely that the information which was provided to the Israelis, which caused that strike, came from a plane flying over Israel from RAF Akrotiri.
And so you have been representing the family, and it is in your opinion, through the interactions from the past several months that you have been doing this, that instead of defending and finding the truth about how a British citizen that was volunteering in Gaza to provide food for hungry people and was killed, that the British government is more interested in defending Israel than it is for finding the truth about the citizen, its own citizen that was killed in Gaza.
Absolutely right, and it's not singly that one citizen. There are a plethora of citizens from this country who have been killed, and you're absolutely right in what you set out. But in addition to that, the British government have shown almost a hostility towards those families. For example, I specifically wrote to the Prime Minister and asked that the family are given an audience with either the Prime Minister or the Foreign Secretary or the Secretary of State for Defence. That took many, many months to come back, and they were told no. Eventually, after much haranguing, they said yes. They said, we'd like to be legally represented, can our lawyers come? There's an explicit no. That can be starkly contrasted with what happened when families of hostages were asked to come to number 10 and they were invited to bring their legal counsel with them, and they had King's Counsel with them, they had solicitors with them. Two different ball games, absolutely entirely.
So in your opinion, there is a cover-up that is going on here, and that is the reason that the UK government is not willing to address the killing of its own citizens?
We have specifically asked on a number of occasions, can we have the footage, can we have the data of the plane that flew over when the aid workers were killed? We've been told no. So whether that's a cover-up, I'm sure you can give an opinion on, but it certainly comes across as a cover-up to me.
Sure.
Based on the evidence that you just provided, you argued that based on the criminal law as we know it, we would be able to find officials in this country complicit of genocide, if not directly participating in it. What would be the limitations of taking this case forward in courts today?
Genocide is a highly politicized crime. In order that any prosecution can start, the Attorney General has to give his consent. Without his consent, the case will be stopped immediately. It is highly improbable that the current Attorney General would give his consent, even though he is a highly esteemed human rights lawyer, because he would be stopped. He would be told, you cannot give consent. If he did, it would be possible that he'd lose his role. Therefore, it is in reality highly unlikely that those who are guilty, especially in the upper echelons of the British government, and I mean Starmer, I mean Healey and other secretaries of state who've taken part, it is highly unlikely that they would see the inside of a dock. If they were, and the evidence was fully presented, it would be very probable that each of them would be facing a sentence in the region of around 30 years.
So it is safe to say that in this case, it is political rather than legal considerations that do not facilitate accountability despite the strength of the case, or at least facilitate the capacity for the British public to see the procedures of the law take their course.
Absolutely. Before any case, be it the smallest case, be it shoplifting, dropping litter, or whether it be murder or terrorism in this country, the Crown Prosecution Service conduct a two-pronged test. The first test is there evidence to show that a crime has been committed? If that evidence is if that evidence is present, then the second test is it in the interests of the public? Is there a public interest that a person is charged? Applying that two-limb test to what has happened in Israel, the first limb can overwhelmingly be fulfilled. There is clear, independent, third-party evidence, both nationally and internationally, that senior officers of this government, public officials, have committed both genocide and war crimes. So limb one is fulfilled. Limb two, is it in the public interest? I can see no greater public interest than war criminals and people who partake in genocide are punished. Example, where there's precedents, World War II. There was not the slightest hesitation in those who took part in killings in death camps were prosecuted and executed. So the only question that is left to be answered is why, if the essential underlying two limbs are fulfilled for a valid prosecution to take place in this country, is there no prosecution taking place? The sole answer is political power.
In fact, the establishment of the Nuremberg process in 1946 was a novel procedure at that time, and that has then set the benchmark for international law on war crimes and crimes against humanity, and that has stood the test of time. We're still there 80 years later.
Absolutely.
It's still in operation. One question for you, and thank you very much for your evidence for us. You said that you believed there was an RAF overflight at the time of the killing. Have you got any clear evidence that we can include in our report which indicates that there is more than a strong possibility that the RAF would have the necessary information to assist you in defending your client?
We've been told there was a flight, but they refused to answer anything further. There are inferences to be drawn from a refusal. If it wasn't the case, in other words, if there was either one, no flight, two, no information, and three, no information relevant to what we are interested in other words, the murder of these aid workers, why on earth would anybody go to the length which the British government have gone to hide something which on their version of events may not even exist? It is the easiest thing in the world to say, we will open our books to you, have a look, we've nothing to hide. But they've closed their books and said, effectively, there's nothing to see here. Well, the whole reason for us asking is to see if there is anything. The fact that you say there is something, but we can't show you, leads us, and indeed leads any reasonable person, to the irresistible inference that there is something to be seen there.
2 quick points to follow that. Have you done an FOI request, and are you able to get a court order requiring the RAF to reveal that evidence?
There will in due course be a coroner's inquest. Because of the complexities and because of the shifting sands, that will take a minimum of 18 months, could be up to 3 years. It is only when that happens, and we are in a coroner's tribunal, that will take place. But we hope eventually, yes.
Thank you very, very much for very, very powerful evidence, and thank you for giving us your time today. It's much appreciated. I'd now like to invite Mark Smith to give his evidence. That's online, I believe, isn't it?
Do you want to say that he's not showing his face? Do you want to say why he's not showing his face?
Mark will be giving evidence, but it will be a voice evidence only at his request, and we've obviously agreed to that. So, Mark, you're very welcome to the tribunal, and thank you very much for giving us your time. We look forward to hearing your statement this morning.
Thank you so much for having me. Can you hear me okay?
We can hear you fine, thanks, Mark.
All right. Well, good morning, everyone, and thank you for having me here. My name is Mark Smith. I was formerly the lead official on the UK Arms Export Licensing Report. This is the report which assesses whether the government is legally compliant in exporting arms to certain countries, and it's particularly used when a given country is involved in an armed conflict. So my role was to gather all of the relevant information on the situation, the airstrikes, civilian casualties, the precision of the weapons being used, as well as any kind of diplomatic efforts that were being made by the UK or the country in question. And then we submit all of that to ministers for their review. So if there's anybody who understands these processes, how they work in kind of intimate detail, then it is myself. And I wanted to speak today because what I witnessed while working on that report was profoundly concerning. While I was working on the report, I was routinely asked to change the report. This was not to correct mistakes or to ensure accuracy, as would normally be the case with a civil service report, but I was actually asked to alter the wording, placement of paragraphs, and to omit key information so that it, quote unquote, sounded less bad. So this is absolutely counter to what we are trained to do as civil servants, and it's something that I have never witnessed in my career, either prior to or following working on this particular report. So I was routinely asked to go to senior directors' offices and told to, quote unquote, make the situation look less bad. So those sections that I'd written, which talked about civilian casualties, for example, I was asked to kind of play them down, make them smaller, put them towards the end of the report and so on. While paragraphs that talked about the kind of so-called efforts that we were making to improve the situation or to improve the precision of the weapons and so on, were asked to be expanded and put, at the front. And there was, maybe several paragraphs on those, and then just like one line on the more negative aspects at the end. It was also fully understood in the department that we would have these conversations in person and not want those conversations to be requested by a court. So for anybody listening here, there have been hundreds, if not thousands, of conversations within the walls of the Foreign Office on the most controversial aspects of our arms sales policy, which will never be seen by the public, which will never be put into a court, even a closed court, because we have them in person. So I was very, very, very troubled by this, and I raised it at the time. Another thing that happened was that we were told to delay the submission of the report until we could find something more positive to add. So this would often happen when there was a particularly appalling example of civilian death. There would be this kind of sort of panic in the department, and we would kind of try to get the government in question to give us some kind of assurance that there was, let's say, an investigation going to be happening into the incident. And then we could put the investigation and all of that front and center of the report to make it look like something good was kind of happening. And so we would delay the report until we could find something so-called positive to put in it. So the culture in the department was very strange, as I say, very different to anything I'd ever experienced in the civil service to that point. Everyone wanted to make it look as though we were on the right side of the law. And any kind of suggestion that maybe we weren't tended to be met with this kind of panic and a kind of extreme pressure to not talk about that. And so I raised such concerns multiple times, as did some other colleagues that were there. But I became so uncomfortable with the situation that I had to step down and say, look, I can't do this anymore. So I went and worked elsewhere in the office, still on the Middle Eastern security. But I always looked on with concern to that team. And a particular example of when I had grave concerns was when Israel was conducting aerial campaigns in Gaza. I couldn't understand how the team were justifying that, because to even an outside perspective, it was very clear that Israel was in breach of international humanitarian law and even committing war crimes. And so the only conclusion that I could come to was that they were using the delay tactic. And because anyone, remembers, Israel would tend to bomb Gaza for quite a short period of time. So I imagine, okay, well, they must just be delaying until the situation moves on, and then they can submit the report and say, oh, well, it's stopped now. So I was always very troubled by that. When, of course, October 2024 came around, the bombardment didn't stop. And so I, at that point, funnily enough, was in Dublin, Ireland, and I was working on political security. So it was actually officially my job to represent UK government policy to the Irish government, which of course is a very close partner of ours, but of course also one of the most opposed countries to Israel in the world. And so I did what you would normally do as a diplomat, which is I went to the team in London and I said, look, can I have some lines to take on this? Because obviously Irish government colleagues are asking me. The lines to take that came back, I knew to be false because of my previous specialty on that topic. And so I went to the team again and I said, look, can you explain this to me? Because, I used to be on your team. So, can you just humor me, clarify some of these lines? At that point, I was met with a barrage of angry emails by legal advisors, warning me off from talking about it, asking me why I was asking all of these questions, and again, telling me off for even writing down my concerns. And so at that point, I realized this is exactly what used to happen when I was on the team. And so I was very, very concerned. I went to my line manager, I went to my ambassador, and I eventually went to the internal whistleblowing team within the Foreign Office. And they were very good, but even with the whistleblowing team, I still got ignored by the Israel-Palestine team, the arms export licensing team. It took months and months and months. I kept asking and asking and asking, and they refused to talk to me. They refused to write anything down. They obfuscated and delayed, and it was very, very clear that I was being blocked out. I also, at that time, asked to be put in contact with some of the other civil servants who I understood had raised concerns. I was told by HR in an email that I was not allowed to speak with them, and that was very shocking. Eventually, I got a meeting with a very senior director in the Foreign Office who completely fobbed me off. Again, it was insisted that this must be a verbal meeting. He refused to write anything down. I set out all of the reasons in detail why it was absolutely impossible to suggest that we were acting legally by continuing our arms sales to Israel. And he simply replied with, well, thank you for raising your concerns, and we will consider them very carefully. And I said, no, I need an answer. I'm your colleague. I'm a fully cleared diplomat. I'm responsible for representing this. I need an answer. And he said, oh, I'm sorry that, this is out of the scope of this meeting and so on. So I knew that it was a complete fob off. So I decided to write to the head of the Foreign Office, the PUS, and also the outgoing and incoming foreign secretaries, because they were crossing over at the time. And I wrote to them saying, I have evidence of serious illegal activity taking place in the Foreign Office. That was in the subject line. It was made very clear, and they both ignored me for months. I followed up with their private secretaries, and they completely ignored me. So the only choice I had was to resign, which was very disappointing. What I've learned from this is that this system is completely unfit for purpose. There's no oversight. There's no independent governance. It's all left up to civil servants under immense pressure from ministers. And I think ministers are kind of hamstrung by their alliances with the USA and so on. So if it were up to me, I would focus, I think, on civilian boycott. This worked in the South Africa apartheid. I think it can work in the Israeli apartheid. A lot of people are concerned by what they see in Gaza, but they don't necessarily make that link between what's happening on the ground and their consumer choices. So those are some brief perspectives as far as I'm allowed to say. That's probably about 5% of what I could actually say, but obviously as a government official, I'm very, very limited. I thank you for the opportunity to be with you today, and I would be happy to take some questions if you have them, although I may not be able to answer depending on the nature of the questions. I'll leave it there. Thank you so much.
Mark, thank you very, very much for that very powerful statement you've given us. I don't know if my colleagues want to relate any questions now. Would you rather communicate later on?
Maybe privately.
Huh?
Maybe we can communicate them later.
Yeah.
Okay.
What I think we'll do, Mark, when we're preparing our report, if we can contact you at that point with any further questions we'd like to put to you, would that be okay?
Sure, yes, I'd be very happy. Thank you.
Thank you very, very much for the evidence you've given us this morning. It's been very, very helpful and very powerful. Could I say thank you also to Matt and to Faz for their evidence they've given today. Very powerful, and we'll include it in our report, and we'll now move on to the next session. Thank you very much indeed.
Our next speakers or witnesses are Fran Heathcote. Fran Heathcote. Fran is a British trade union leader and the current General Secretary of the Public and Commercial Service Union, one of the UK's largest unions representing civil servants and public sector workers. She previously served as president of the union before her election as General Secretary in 2023. Welcome, Fran. Following Fran, we will have Dr. Sarah Husseini, who is a director of the British Palestine Committee, an independent policy group offering a British Palestinian perspective on UK policy toward Palestine. She previously served as an advisor to senior officials within the PLO and the Palestinian ambassador to Germany. Dr. Husseini sits on the board of Build Palestine, the Britain-Palestine Media Center, and the Palestine Institute for Public Diplomacy. And finally, Eyal Weitzman, who is the founder and director of the Forensic Architecture and professor at Goldsmith University of London, where in 2005 he founded for research the Center for Research Architecture. In 2007, with Sandy Hilal and Alessandro Petti, he established the architectural collective DAR in Betzahur, Palestine. Thank you all for agreeing to come and give us testimony. Fran, the floor is yours.
By way of introduction, PCS represents around 190.
Can you go closer to the microphone, please?
Oh, I'm sorry. Is that better? Yeah. By way of introduction, PCS represents around 190,000 members working mainly within the civil service and its related areas. A number of our members are engaged in functions which may involve interactions with the government of Israel. So, for example, we have members working in the Foreign Commonwealth Development Office, Home Office, Ministry of Defence, and the Department of Business and Trade. So our role, first and foremost, PCS exists to protect and promote the interests of its members. The vast majority of our members are civil servants who have obligations under the Civil Service Code and their contracts of employment to implement government policy. However, it's often the case that the functions that our members are asked to perform are not in their interest. It's here that the trade union steps in to represent them collectively. It is also the case that the policies of the union, democratically decided on an annual basis at our conference, often conflict with government policy, and PCS therefore often campaigns against government policy. So to give an example of such a campaign, PCS represents members of the Home Office. Those members are responsible for implementation of the asylum and immigration system. PCS considers the system to be oppressive and inhumane, and we campaign for a more progressive system. In recent years, we've taken judicial review action in respect of that system, which prevented the government from instructing our members to perform a dangerous pushback manoeuvre on small boats in the English Channel, which would have undoubtedly cost lives. We prevented the government from unlawfully deporting refugees to Rwanda, with the Supreme Court confirming that that policy was unsafe and unlawful. And in respect of these campaigns, we are clear that we are campaigning for a more progressive government policy, that we are standing in solidarity with the victims of aggressive government policy, and that we are campaigning to protect and promote the interests of our members in order to prevent them from having to work in such hostile environments. So our position on Gaza then, for some considerable time, PCS has been raising concerns across various government departments and with the Cabinet Office regarding the situation in Gaza and the implication for our members. We have been raising those concerns on behalf of PCS members who have been raising their concerns with us. So why is that an issue for PCS? Our primary purpose, as I say, is to promote and protect the interests of our members, and we don't believe that it is in the interests of our members to be placed in situations where they are potentially being asked to act in breach of the law and their obligations under the Civil Service Code. We're also keen to ensure that our members' rights and freedoms are protected. We're also clear that we stand in solidarity with the people of Gaza who are experiencing unimaginable horror. As a progressive organisation, PCS will do all it can to stop war and to facilitate peace. So our concerns specifically are the following. We've been raising concerns about the legality of the work being undertaken within the civil service and its related areas, which involves interaction with the government of Israel. Our members' obligations and the employer's interpretation of them under the Civil Service Code, on our members' rights and freedoms, particularly in respect to the Equality Act 2010 and the European Convention of Human Rights. So on the 26th of January 2024, the International Court of Justice ruled that some of the alleged acts of Israel and Gaza could potentially be considered within the provisions of the Genocide Convention. PCS concurs with that view. The fact that the International Criminal Court is seeking an arrest warrant for the Israeli Prime Minister only reinforces it. We believe that the UK government has an obligation to do all that it can to prevent acts of genocide, and that includes stopping all work within the civil service and its related areas, which in any way potentially enables acts of genocide. We are not satisfied that the employer has obtained or even sought legal advice on the legality of these actions. For example, in continuing to approve arms export licenses to Israel and in continuing with negotiations on a free trade agreement with Israel. PCS also believes that in forcing our members to continue to undertake work involving interactions with the government of Israel, the employer is potentially putting our members in a position of conflict given their various obligations under the Civil Service Code. We believe that the employer is also potentially asking our members to act in contravention of the law. We further believe that across some areas of the civil service and its related areas, the Civil Service Code is being used to prevent our members engaging in activity to help the people of Gaza. We believe that it's been interpreted by the employer in an overtly restrictive and potentially unlawful manner that interferes with our members' rights under the Equality Act 2010 and various articles of the European Convention of Human Rights. We have been raising these issues with the Cabinet Office to discuss these matters and to hopefully negotiate a satisfactory resolution to them. We have provided copies of all that correspondence, and if you haven't got them yet, we will make sure that you do. We have formally written to the Cabinet Office on 3 separate occasions raising our concerns, where we have raised that the ICJ ruling and our concerns that follow about the legality of the work that our members are employed in under the Civil Service Code and their rights and freedoms. Our concerns about confused messaging from the government, having initially supported Israel's position unreservedly, there appeared to be a long overdue shift in the UK government's position. On the 20th of May this year, the Foreign Secretary David Lammy made a statement in the House of Commons on Israel and on the occupied Palestinian territories. He acknowledged that the Israeli Defense Force had started a new extensive ground operation throughout Gaza, that Prime Minister Netanyahu had said that they're going to take control of the Strip, letting only minimal amounts of food reach Gazans, and the stark warnings from the UN and the WHO of the threat of starvation hanging over hundreds of thousands of civilians. The Foreign Secretary condemned this as abominable. However, that shift in position appears to have been subsequently undermined in at least 3 significant ways. Firstly, 1 week after the Foreign Secretary's robust statement, the UK government permitted its trade envoy, Lord Austin, to visit Haifa in what appeared to be a trade cooperation trip approved by government officials. Secondly, the Madeleine, a UK-flagged civilian ship en route to Gaza to provide humanitarian aid, protected under international maritime law, was intercepted and boarded by Israeli forces, seemingly in violation of the UN Convention of the Law of the Sea, and an affront to the UK sovereignty that appears to have gone unanswered by the UK government. And thirdly, the dismissive response to the genuine concerns raised in correspondence to the Foreign Secretary by our FCDO staff regarding the UK government's interaction with the government of Israel and the potential exposure of civil servants that this creates. We highlighted that on the 16th of May. Staff in the FCDO wrote to the Foreign Secretary, raising a range of concerns and calling for substantive and tangible actions to address them. Those concerns included Israel's violations of international humanitarian law and potential UK government complicity. The letter called on the Foreign Secretary to urgently consider with the utmost seriousness those recommendations and the continued impact on the UK's reputation should we maintain our existing relationship with Israel, while they made clear in word and deed their intention to disregard international law. The response from the government was nothing short of a disgrace. The response offered SCDO staff conversations with HR and counsellors. That is simply not a serious proposition to address the genuine issues raised by the staff of potential complicity in genocide. It went on to suggest that civil servants may wish to resign if they're uncomfortable with what they're being asked to do, and that is simply reprehensible. It is a dereliction of duty and a startling ignorance of the provisions of the Civil Service Code, which require all civil servants to act in accordance with the law, including international law. We said that such confusion cannot be allowed to reign on such serious matters. Civil servants must be able to clearly understand what the government's position is if they're going to fulfil their roles and obligations. Subsequently, in Gaza, since our correspondence began, those concerns have only been magnified, including the acts of the government of Israel, some of the statements made by its ministers and spokespersons, making it blindingly obvious that potential war crimes and acts of genocide are underway. The latest figures from the Ministry of Health in Gaza indicating that 54,607 Palestinians have been killed and 125,341 wounded. UNICEF considers that 14,500 Palestinian children in Gaza have been killed by January, and many more will die from military aggression and an effective aid blockade should Israel's siege of Gaza be allowed to continue. Our annual conference decision in May confirmed that view, that we are committed to support the Palestinian people in their struggle to achieve freedom from Israel's cruel and unjust apartheid system and the achievement of a free and independent state. Our conference agreeing that no member should be put at risk of being liable for aiding or assisting genocide as a result of working on or actioning British government arms export policy and licenses to Israel, and that we would fully back any member facing any sort of disciplinary action for refusing to act or work on an arms export license to Israel. So in conclusion, the Civil Service Code obliges our members to act with integrity, including complying with the law and upholding the administration of justice, with honesty, including setting out the facts and relevant issues truthfully, objectivity, including not ignoring inconvenient facts or relevant considerations when providing advice or making decisions, and impartiality, including carrying out responsibilities in a way that is fair, just, and equitable, and reflects the civil service commitment to equality and diversity, and including not acting in a way that unjustifiably favours or discriminates against particular individuals or interests. PCS believes that the UK government is asking civil servants to undertake interactions with a government engaged in a genocide, ignoring their concerns about such interactions, ignoring the concerns that have been raised by their trade union on their behalf about such interactions, ignoring the provisions of its own civil service code, and ignoring a whole range of domestic and international legal obligations by which it is bound. Thank you so much for listening.
Thank you so much for that.
Fran, thank you very much for the evidence you've given. Just to be clear, civil servants are required under the Civil Service Code to work for the policies of the government of the day, but also required to work within both domestic and international law. Have any of your members come to you directly asking for legal advice on potential discrepancies or breaches of law on the work that they've been asked to do?
They have repeatedly. Unfortunately, we were unable to seek a Freedom of Information request to obtain the legal advice because it's covered by legal privilege. So the only way we can get that is if the government agreed to release it. So although we have been asked, we are seeking legal advice and we continue to do so. One of the problems that we have with the legal advice is that it does require individuals to raise those concerns as individuals, and we're unable to do that collectively, which is causing some fear, I have to admit, amongst our members. So we can continue to discuss with our lawyers to pursue all avenues in terms of legal advice, but it is quite difficult and quite brave for a civil servant as an individual to raise those concerns, which is what the current legal advice requires those members to do.
We heard earlier from Mark Smith that he and colleagues in the Foreign and Commonwealth Office had been told to have conversations about delicate matters and not to record or repeat anything. Is that something you pick up more generally within the civil service, or is this specific to the Foreign Office?
We have picked that up in more than one department, but again, it's sort of informal concerns that are raised with us rather than anything that we have been able to pursue legally. But we do get repeated feedback, not just from the FCDO, about the nature from which people are allowed to discuss this and put down their concerns.
Thank you.
Are you able to tell us if, so far we've heard about these concerns coming from civil servants from the FCDO, but any other governmental departments where similar concerns have been raised?
I think, as I say, we do represent members in all civil service departments, and the other area specifically has been the Department of Business and Trade. Yeah.
So another question. So based on your testimony, it is safe to say that at the moment, there is no reasonable path for civil servants to ensure that they are not found complicit in genocide, except giving up their livelihoods.
Yeah, I mean, the response that was provided to the members that raised their concerns was that they could seek counselling or they could resign. And we don't think that's acceptable, and we don't think that's something that is a reasonable response to what are very legitimate concerns, and every day are backed up by more and more evidence that actually what is happening could put them in conflict with the law.
Absolutely, and they could be held accountable.
Yeah.
Thank you very much for this important testimony. Sarah, the floor is yours.
Thank you. Thank you for the invitation. Is the microphone
Please.
close enough? No?
Now.
Closer? Is that better? Okay. I'd like to start, I think, by taking a moment to pay tribute to the courage and the civic commitment of our people in Gaza, the healthcare workers, the journalists, the recovery teams, the communities who are really embodying the very definition of humanity. Now, while the national emergency that we as a Palestinian people are facing today is unprecedented, it cannot be seen as an aberration. Rather, the past 2 years of mass murder, starvation and forced displacement that have occurred during this ongoing live-stream genocide are the culmination of a process more than a century old. Since the very foundation of the State of Israel premised on the mass ethnic cleansing of Palestinians, successive Israeli governments have advanced twin goals of maximising domination over the land between the Mediterranean Sea and the Jordan River, while ensuring the fewest number of Palestinians remain on it, a principle that was just repeated publicly by the Israeli Minister of Finance almost verbatim just this week. Now, throughout this time, Israel has relied upon the support, diplomatic, military, economic and ideological, of a handful of powerful states. Britain, often historically miscast as innocent bystander, hapless arbiter, or even tragic victim, has in fact been remarkably consistent in aiding and abetting Palestinian dispossession. Britain's first Labour Prime Minister Ramsay MacDonald gave the Balfour Declaration, quote, his full backing in 1917. Then, at its annual conference in 1944, the party adopted a resolution endorsing the ethnic cleansing of Palestine, making, quote, transfer of population, end quote, in which Palestinians would be, quote, encouraged to move out, quote, of their homeland, official Labour policy. Today, we're seeing this ongoing diplomatic support for Israel, justifications for atrocities being committed, dehumanization of Palestinians in political rhetoric and media discourse, efforts to undermine Palestinian attempts at accountability, the demonization of international solidarity, and most egregiously, in the active military assistance rendered to Israel as it commits its ethnic cleansing and forced displacements of Palestinians on a scale we haven't witnessed since 1948. Now, as we heard in part 2 of this tribunal, the UK has a duty to play a critical role in supporting Palestinians in their long struggle to return to their homes and live in freedom in their homeland, to address the root causes of injustice and take steps to fulfill its own obligations under international law. In November of last year, the British Palestinian Committee, an independent organisation of Palestinian experts in the UK, released a comprehensive policy guide for the new Labour government. The guide proposed a clear, evidence-based framework which is grounded in justice, freedom and international law, and it set out 3 urgent priorities. First was to actively and urgently work to stop the genocide in Gaza and end the UK's complicity in ongoing violation of Palestinian rights. The second, to uphold the inalienable rights of the Palestinian people, including the rights to self-determination and return. And third, to defend the public realm in Britain and protect Palestinians here from discrimination and intimidation. Now, over the past year, Keir Starmer's administration has failed to implement almost every recommendation. In several instances, the government's actions have actively perpetuated and worsened the violation of Palestinian lives and rights. So what I'd like to now do really is highlight just 3 examples of Britain's involvement under each of the aforementioned priorities that we set out. So first of all, with regards to stopping the genocide, first and most damning of all, the UK is still providing military support to Israel. As we've heard from experts this morning, this goes far beyond the continued licensing of arms exports, including the supply of F-35 parts through the spares pool, without which Israel's fleet would simply not be mission capable. The British Army's been training on British soil a number of Israeli military personnel active in the genocide, and Royal Air Force bases are being used to ship military cargo and send surveillance flights to Gaza on an almost daily basis. Second, with regards to wider trade with Israel, and actually this is something Fran just mentioned as well, while we saw the government announce the suspension of trade negotiations in May, UK ministers made it clear that the suspension was only limited and temporary. In fact, it seemed to last only a matter of days, with the UK trade envoy to Israel announcing via X just a week after the Foreign Secretary's statement that he was in Israel to, quote, promote trade with the UK. So without any kind of economic or diplomatic sanctions, Israel will never be compelled to abide by its international obligations as set out inter alia in the ICJ advisory opinion on the legal consequences of Israel's prolonged occupation. Thirdly, ministers have refused to support the South African submission at the ICJ in the genocide case against Israel, and also push for the prosecution of ICC by the International Criminal Court, the ICC, of Israeli officials for war crimes and crimes against humanity. While a growing number of states, such as those that make up the part of the Hague Group, as well as Belgium, Norway and Spain, have taken positive action to address the unfolding genocide, the UK remains a glaring outlier, increasingly politically isolated and morally adrift. In terms of upholding the inalienable rights of the Palestinian people, including the right to self-determination and return, the UK is yet to formally recognise that Israel's laws, policies and practices meet the legal definition of apartheid and take the appropriate and effective action to remedy this crime, which it could do so by such means as pushing for the reconstitution of the UN Special Committee Against Apartheid and the UN Centre Against Apartheid. Regarding UNRWA, while the Labour government restored some funding to the agency following the previous government's appalling decision to suspend support at a time when Palestinians needed their services the most, the restored funding has remained lower than previous levels despite the greatly increased need. Moreover, this government, as with previous governments, has failed to defend UNRWA from long-standing attacks designed to delegitimise and undermine the Palestinian right of return, particularly following the banning of the agency by the Israeli Parliament in October of 2024, which contravenes the 1946 Convention on the Privileges and Immunities of the United Nations. The UK government has similarly failed to prevent attacks on the agency's operations in Gaza, and above all, its distribution of aid, which has been systematically undermined by the Israel and US-backed so-called Gaza Humanitarian Foundation, creating a new system that's been described by UNRWA as a killing field. Meanwhile, only yesterday, the Trump administration added several more of our frontline human rights defenders to their sanction list, including Al-Haq, Al-Mazan, and the Palestinian Center for Human Rights. This government should be acting urgently to condemn and reverse such decisions. On the right to self-determination, we saw on the 29th of July that the Prime Minister threatened Israel with the recognition of a Palestinian state, unless Israel takes steps to re-allow food into Gaza, agrees to a ceasefire, and promises not to annex the West Bank. Now, in the context of an ongoing genocide, which is unfolding with British support, this symbolic and conditional recognition from the UK will do nothing at this time to safeguard the Palestinian people's inalienable right to self-determination. In fact, it's actively undermining international law by casting the right to self-determination and the illegality of the occupation as negotiable. So this really, along with other minimal steps taken by the government, limited arms licence suspensions, sanctions on individual settlers, announcement of trade talk suspensions that seem to have not borne out, really just represents a very performative and cynical attempt to diffuse the pressure that the government has been facing in its role, over its role in Gaza. Lastly, in terms of the rights of Palestinians here in the UK and the defence of civil liberties of those standing in support with Palestine, what we've seen is that through their hostile foreign policy, successive British governments have entrenched structural racism against Palestinians in the UK. This has been consistently reinforced from Downing Street and across British media, and is exemplified by things like parroting the self-defence rhetoric invoked by an occupying power against an occupied people, by Keir Starmer's endorsement of Israel's siege on the entire population of Gaza, just to name a couple of examples. Today's Labour Party in opposition and government has supported laws and policing actions that severely restrict peaceful process and expressions of solidarity, including prescribing civil disobedience groups like Palestine Action, meaning that demonstrators now potentially face years in prison for protesting this country's involvement in the mass murder of women, men and children. Furthermore, the government has remained silent as students mobilising for Gaza on university campuses, employees in their workplaces, and hundreds and thousands of people taking part in demonstrations have faced intimidation, disciplinary actions, and police interventions. And finally, here in Britain, watching helplessly on as their loved ones are bombed, displaced, and starved, Palestinians from Gaza have campaigned for a family visa scheme based on the Ukrainian model until it is safe to return home. The government has consistently refused, despite cross-party calls and a petition with over 100,000 signatures. And earlier this week, we saw the Home Secretary suspend refugee family reunion altogether, the only legal route for spouses and children under 18 to join loved ones. This move will have a devastating consequence for anyone seeking to bring family members to safety, and takes a sledgehammer to the professed principles of the Labour Party, as this government continues to pander to a far-right agenda. So in closing, the members of this tribunal, the policymakers in the buildings around us, and the wider British public should be under no illusion. We are witnessing one of the most heinous crimes in modern history. What is being inflicted upon Palestinians, our loved ones in Gaza today, will forever be remembered as a stain on our collective humanity. And yet, despite all of the horrors, there still remains an opportunity to change course. Britain has the legal, moral, historic obligation and the power to do so, to prevent the extermination of the Palestinian people, to correct the historical injustices of British colonialism and right the present injustices of Israeli colonialism. Ending all forms of military, diplomatic and economic support for Israel's genocide must be the absolute priority in order to protect Palestinians in Gaza and across Palestine. This must go hand in hand with accountability for the countless crimes that have been laid out through hours of testimony yesterday and today. Anything short of this amounts not only to complicity, but participation. Thank you.
Thank you very much. Do you have questions? You go.
So just for the purpose of our later discussion, two statements, if based on your witness statement. First of all, so on an international level, the UK has refused to engage in multilateral efforts to promote international peace and security as well as equality. And the second thing is, and I was wondering if you could give us a further example, in that British citizens of Palestinian origins were not protected and treated equally, rather exceptionally, and have faced cases of intimidation as well as deprivation of their basic human rights, such as the right to family and the right to movement. I'm wondering if you could comment on these statements.
Yeah, I mean, to take the British citizens of the UK or Palestinians resident in the UK, as you say, we've seen across a lot of different areas, employment discrimination, surveillance, limited access to services, that things that in some ways affect a number of different communities in the UK, but specifically in the case of Palestinian, there is an element of a specific attempt to suppress Palestinian identity, history, and the lived realities of Palestinians, which is part and parcel of Britain's role in Gaza. So there's a real connection between the foreign policy and what happens here in terms of domestic policy. And so there is always this underlying racism, structural racism that Palestinians face here in the UK.
Just to make sure I understand, so we've been hearing here about a politics of deception and a cover-up by the British government about its complicity and maybe even participation in the genocide. And what you're telling us here today is that those that are trying to uncover this, particularly Palestinians here in the UK, are being discriminated against, being shut up and hounded basically by the UK government. Is that the case?
It's the case that the UK government is often standing by and allowing this to happen through other forums, whether it's through universities or through employers. And actually, it's not even about Palestinians who are trying to uncover some of this stuff. It's about Palestinians trying to live. I mean, it's unfathomable that you have a group of people who are suffering, whether directly through family members in Gaza being bombed and murdered and starved, or by seeing their people in this situation, suffering this kind of trauma, and then having a second layer of trauma of then when you actually try to even speak about that or speak to your reality or your lived experience, your history, that then you are disbelieved, interrogated, intimidated, silenced. If you go a step further and decide to protest these things more publicly, then yes, there's people people have been dismissed from jobs, people have been intimidated and silenced all over the place. And it's unbelievable that while a community that needs actually more support than ever before right now is actually being demonized and victimized in this way is
Thank you very much for... Yes, please.
A quick follow-up. I'm wondering also, because we've heard a lot about this, which is the role of the Israeli lobby and the UK's government also tolerance of that in the role of further intimidation of Palestinians. And I'm wondering if you have any comments in regards to that.
I mean, I can't speak. I'm not in the room with with those who are lobbying. But what I can say is I can say the experience that we've had as British Palestinians and Palestinian organisations in terms of trying to access government, and that is that we've been met with effectively silence whenever trying to reach out. So I think, for example, we sent maybe 5 letters, it was 5 letters between August 2024 and October 2024 to the Foreign Secretary around specific attacks that have been happening on Gaza. Sometimes it was schools, sometimes it was different areas. There was a coffee shop in Tulkarem as well in the West Bank that was bombed during that time. And were met effectively with silence over that period. So in terms of having any kind of access as Palestinians, there is very little with the leadership of this country. And my understanding from what I've read and what I've seen and what we've all seen is that that's not the case when it comes to those advocating for Israel.
Thank you.
Thank you very much, Sarah. Professor Eyal Weizmann, the floor is yours.
Thank you. Thank you very much. By way of introduction, I'd say that forensic architecture has been in the past 5 years, since 2020, in partnership with Al-Haq and formed the Al-Haq Forensic Architecture Unit. You all know that yesterday Al-Haq, together with Al-Mizan, PCHR, have been sanctioned for their work on the ICC. I've spoken to Shawan Jabarin this morning, was thinking actually this is an opportunity. In fact, the sanction is an opportunity to isolate Israel and the US government further. Al-Haq has obviously been also designated as a terrorist organization alongside 7 other groups of Palestinian civil society, has been raided, including our colleagues' team there, the Al-Haq Forensic Architecture Unit. So I think that we are in a situation where genocide, we need to understand the Israeli genocide in Gaza as including within it, as historically is always the case, genocide denial. So there is no genocide without genocide denial. A genocide denial is not a rhetorical act. Genocide denial is operating in the field of policy, it's operating on the ground, it's operating as the targeting and murdering of journalists and human rights defenders. And genocide denial is what enables genocide. In fact, they're two parts of the same thing. It's not like we are talking here about something that is external to what is happening in Gaza. It is the same process. Also, by way of introduction, forensic architecture has in the past year and a half been working closely with the South African legal team and been producing reports that have been used in the submission at the ICJ. I will not present this work, but I'll be happy to answer questions about it later if this is necessary and wanted. I want to use my testimonial today to speak about really what we are engaging with right now, as in the past few weeks. The destruction of Gaza City that is happening as we speak, and particularly the relation between construction and destruction. The reconstruction plans, some of which endorsed by the British government, and the way that they are entangled with the patterns of destruction that we see on the ground. In a sense, what I want to show is that planning, whether it is by Arab government, Egypt-led master plan, or the deranged new plan that has been proposed by the same planners that designed the Gaza Humanitarian Fund, murderous rationing stations in southern and central Gaza, use architecture as the continuation of genocide by other means. And endorsing any that design for Palestinians over their heads and design actually plans of reconstruction on the mass graves of Palestinians in Gaza, ignoring Gazans completely, is directly continuous with the destruction that is happening. And I'd like to show that. So this is really a plan that has been produced in the past few years. Everything in red here is areas that are already being destroyed. And when we are speaking about destruction in Gaza, it's different than any other form of destruction that forensic architecture has seen over the years. It's not like buildings are destroyed and falling onto the footprint, but a form of destruction that needs to be understood as ungrounding, in which no surface features are left. So all the area in red is a certain kind of desertification, if you like, in which all plot lines and all surface features have been removed. Palestinians have been pushed precisely into the sand dunes, as you see here in an older aerial image of Gaza. You could see that Gaza effectively has two types of grounds, of soil. The sand dune in the south is where Palestinians are being pushed to as a kind of a waiting room on their way to expulsion. These are the sand dunes, and these arrows are not arrows that are graphically added by our team. These are collected from Israeli expulsion order, all of them leading onto the sand dunes of Al-Mawasi. This is the kind of past few weeks.
Yeah, maybe. I don't like it like this, but maybe it's easier to
coming all direction, kind of gradual kind of shrinking of the living space. There is and expulsion of people from it. And I want to suggest that these acts of ungrounding, of total ungrounding, very similar, by the way, to the type of ungrounding that we've seen throughout the Nakba of 1948, are an attempt also to reshape, to redesign by destruction. As I said, the kind of destruction is not one in which anything is left on the surface. It's not one in which, buildings could, after a war, even if destroyed, could be extruded of all surface features that are the organization of life. Some of those destroyed buildings that are being used as building material are actually mass graves. You would see that some bodies that could not have been recovered are being left within rubble. Some of that rubble is being recycled, and we have seen evidence also of that rubble exiting Gaza into Israel as building material. It includes mass grave. Gaza is both a demolition zone, active, systematic demolition of all traces of Palestinian life, and a construction site in which the rubble of destroyed buildings is being piled up to create infrastructure for the Israeli army, barriers, bases, detention facilities where Palestinian men of military age are being tortured, sometimes to death. These are the kind of construction that we see continuously in Gaza. I mean, Gaza is a relatively flat area, and Israeli bulldozers are raising it into a landscape, continuously shifting landscape, in which the rubble of the destruction of everything that Palestinian life was is reshaped into those almost military bases that are tracing the footprint of the history of Israeli settler colonial project in Gaza. That on the same places where the roots were, where the settlements or the old colonies in Gaza were, we see now huge military bases that could be turned easily into settlements. So of Gaza is being used to design it for the creation of these concentration camps, those waiting zones at the southern edge of Gaza, on the way for expulsion, in order to channel people, incarcerate them. All the architecture is made out of this rubble. Now, on the 4th of March, 2025, in a summit of Arab states, Egypt has presented this master plan for Gaza reconstruction. And we've done an analysis on it. But it's really important to say that this master plan has won the endorsement of Britain, together with other EU countries. And I'd like to show you how that plan is actually the continuation of genocide by other means. So that plan sees a green area, almost like, the green belt around London, placed around Gaza, precisely where Israel, on the right, you would see the path, the footprint of destruction. On the left, you see the Gaza plan, and you see that the plan is actually building what Israel calls the buffer zone into its logic. You may know that the two main corridors and the kind of site of destruction are along the Philadelphia corridor between Egyptian and Palestinian Rafah, and along the Netzarim corridor. Those have been built into the plan that is endorsed by the British government. In fact, the Israeli destruction has shaped the logic of reconstruction. These are the raid routes, these are the pathways along which, throughout the history, of the colonization of this southwestern coast of Palestine, Israel is used to raid Palestinian refugees in Gaza. During the genocide, they've been thickened and broken through, again, widened into huge corridors. And then when we look at the plan that was endorsed by Britain, we see that they've been built into that master plan. So, in short, the reconstruction of Gaza by other people than Palestinians are effectively tracing the path of destruction and continuing its logic. A logic that is a settler colonial logic of redesign of other people's habitat. Here is the refugee camp of Jenin, empty of its inhabited. 40,000 Palestinians have been expelled. As the Gaza doctrine is being applied now also to the West Bank. It is refugee camps like Jenin and others in the north part of the West Bank that are being redesigned by destruction. And now back to the master plan, or this kind of image that has been produced precisely by the same people that have designed the Gaza Humanitarian Fund Foundation, with the participation of this person on the right. And it seems to me that any work, and with this I want to, Britain endorsing other people designing anything on the sites of mass grave. Literally, I've shown you graves that are building destruction that are grave. Of course, one could say Israel itself is a kind of beachside development on Palestinian mass graves. But in that case, we are seeing an image of reconstruction that is genocidal in its nature. There are plans, there are Palestinian plans. The Phoenix Gaza is created by a group of Palestinian planners, both within and outside Palestine, that are thinking, and I think in a right way, about the future of how Gaza would be, and would have to negotiate, of course, the difficulty of designing within a place that has been conceived as a refugee camp, that maintain the right of return and the claim for return, while actually respecting the social reality that has been produced there. And again, I think that Britain endorsing any plan that is not made by Palestinian is genocidal. Thank you.
Thank you very much. Thank you very much for this, Jeremy.
Lyle, thank you very much for the very powerful evidence you've just put to us this morning. Two questions. I've been in Gaza many times over the years, particularly before 2015, and in my memory, the majority of the eastern part of Gaza was less densely populated, and there was a considerable amount of agricultural activity going on there. And indeed, at one point, there was an attempt to turn Gaza into a sustainable production of fresh fruit and vegetables to feed the population. What evidence have you got, not just of what's happened to those very successful agricultural projects, and they were very successful, and have any defoliants been used on the ground which would make the return of agriculture there impossible? And secondly, the point you made about the destruction of buildings and the numbers of bodies that are found within them, have you any evidence, or is it possible that the rubble that is now being used as hardcore for construction by Israeli forces could actually contain human remains within it?
Yeah, thank you. So I think it's important to mention in my testimonial that historically, and I'm talking about the end of the period of the Ottoman Empire, beginning of the British Mandate, the area of the northern Nakab has been the breadbasket of Palestine. It's contained some of the most fertile soil. The Wadi Gaza basin is extremely fertile. It was the center of production of wheat and barley. In fact, the British beer industry at the end of the 19th century was relying greatly on export of barley from the Gaza precinct in this time. During 48, obviously, Israeli paramilitaries and then the Israeli army tried to dislodge all Palestinian community from the fertile areas of the Wadi Gaza basin and push them towards the sand dunes. But a sliver of fertile land has remained within the area that was protected historically by the Egyptian military. So if you want, you can think of Gaza as divided in half on east and west of the Salahuddin Road, or the old historical Via Maris, perhaps the oldest route in the world. West of it is sand dunes, east of it is this fertile Lurs, and it has given ground to enormous agricultural activity over the years. From strawberries to citrus trees to also wheat and barley that was there. But Israel always tried to unground that area. That means to say desertify the area that is immediately west of the armistice line, the boundary of Gaza. And it has done so with bulldozers flipping over Palestinian orchards and fields. And since 2014, it has done so with dust croppers, using herbicide. And this is one of our investigations in forensic architecture. We showed how Israeli planes, dust croppers, are using at the time that the wind goes from east to west, they are spraying the defoliants in order to kill old plants on the west side of the border. So anyone that has managed to maintain agriculture in this area has done so against all odds. But there were robust agricultural activity really as an act of resistance and defiance against all odds at this time. When the genocide, current phase of the genocide began, the policy, we need to think of the policy of starvation that was imposed on Gaza as containing a combination of acts. Initially, from the end of 2023, beginnings of 2024, at Forensic Architecture, we've seen a systematic destruction of all agriculture along the armistice line, in the east of Gaza, and in the west of Gaza, all systematic destruction of all fishing boats. So from both those sides, the destruction of Palestinian food sovereignty, the ability to feed themselves, to produce food for themselves, created a situation in which every calorie that enters is under control of the Israeli occupation forces, was monitored, calculated, and of course, never, even when a bit more and sometimes less food was allowed in, was never near sufficient quantity. But it became a full leverage because you need to do that in order to produce starvation. So the architecture of starvation, if you like, begins already by that destruction, and then slowly by attacks on aids, on bakeries, on food warehouses, etc. About whether there are, we know that there are 10,000 Palestinians missing. There's simply, and I think by now perhaps the number is bigger, unaccounted for in the official death toll of the Palestinian Ministry of Health. And given the form of destruction, given the way that buildings fall into deep craters of the kind of munition that are being thrown at them, sort of what is called ground-penetrating bombs. The bombs that Israel is throwing are exploding sometimes 20, sometimes 30 meters under the surface. What that creates is a type of collapse that brings the building into the crater, and it's covered by the remnant rubble, There is simply no means with the existing means that are left in Gaza to retrieve those bodies. So those bodies are effectively deep in the subsoil. And so if you take that soil, if you remove that soil, if you use building rubble as construction material, whether it is in Gaza itself for military bases, or if you take it out, or even if the US military, when they build a pier during the winter of 2024, that is being built with material that is most likely containing human remains. So it's built out of mass graves. I want to say another thing about that form of destruction, that buildings are kind of like solid toxic waste. There's a lot of material that go into buildings everywhere. In Gaza, there's also a large quantity of asbestos still in places. When you demolish buildings, you pulverize them, that all these materials are released either into the subsoil or into the soil. And the pollution that makes on the soil itself, according to experts that we've been in touch with, would take decades to actually remove, if at all. So you take the most fertile agricultural soil and you've made it toxic for generations to come. Of course, you know, when you cultivate, we see just the top of the soil as the surface, but everything that grows on the top, dependent on a biomass, if you like, that exists tens of meters into the subsoil. It's, you know, the bacteria, the worms, all organic activity that happens in the subsoil have been destroyed. Thank you.
Thank you very much for this. Another just quick question, ma'am, which is, you've explained to us the plan that has been put forth, as well as the fact that it's endorsed by the UK. In practice, what would such a plan facilitate? Or if this were to be the future of Gaza, what would this mean for the population within it, as structured as we see it?
So initially, it would require, and these are the plans, the forced displacement of people. When you build as a tabula rasa over, and nothing in those plans that I've seen respect any footprint of any of the Palestinian cities, villages, refugee camps. These are historical places. They are sets of relationships that have been formed there over the time. I think Palestinian political identity and Palestinian political struggle so bound up with Gaza, with the refugee camp of Gaza. When you say, when we look at places like Jabalia, that have been completely ungrounded. It's not only destroyed, and I want to make clear, ungrounding is not destruction. It is the eraser of everything on the surface. You erase that political history that has been inscribed in the physical structure of place. Practically, if you put a grid of buildings that completely ignore what was there before, as we've seen in the plan that was endorsed by the UK, necessarily it means that all that area is a construction site. The way that architecture or development works is that you need to systematize this kind of construction. You need to remove, nobody could live at a place where things are rebuilt. So it means effectively a plan for ethnic cleansing. When people are out, would they be allowed in? I didn't see that historically happening in 8 decades of Israeli settler colonization, that Palestinians that are out were allowed back in. So I think wherever they say, you take people out, this is forced displacement. Again, by architectural means. We have seen in the ceasefire of the winter of 2025, Palestinian returning to Jabalia, returning to Gaza City, and building, either setting their tents or temporary structure by their homes. Sometimes, if something remained, cleaning up those areas, rebuilding on the footprint of what existed, and living as rebuilding, or rebuilding through life. And I think that this is something really important, motivating. It's an admirable act of resilience, but it's also a manifestation of society's sovereignty and right to do so. And anyone that would design over Palestinian heads in accepting the tabula rasa created by Israel is effectively continuing directly Israeli military destruction, and not only that, encouraging it. Because when Israel has seen those plans produced before it broke, so the 4th of March, the Arab Master Plan endorsed by Britain and the EU has been published. And you're a general in the Israeli army and you see, oh wow, they accept our pattern of destruction. Let's continue. It's feeding that kind of positive feedback loop of a future image driving present destruction driving the future image, etc. So, plans and architecture is not simply a ghost that is kind of in the future. It feeds into the present, and this is something that we must bear in mind, and this is why we must resist and make sure that Britain is held accountable for endorsing such plans.
Thank you so much, Eyal, and thank the other witnesses, Sarah and Fran. I think your contributions here have been extremely important for the panel, and we will definitely integrate them into our final report. Shad?
So now we'd like to invite our last two witnesses for this session. And our first speaker is Professor Richard Falk, who is an emeritus professor of international law at Princeton University, where he taught from 1961 to 2001. He's a leading scholar of international law and global governance, with a practical focus on human rights in the Middle East. From 2008 to 2014, he served as United Nations Special Rapporteur on the situation of human rights in the Palestinian territories occupied since 1967. He's currently chair of the Board of Trustees at the Euro-Mediterranean Human Rights Monitor. Professor Falk, the floor is yours.
Thank you so much. It's a privilege for me to participate in this historic effort to hold the British government accountable for its complicity up to this point, and to hope that going forward it will act responsibly with respect to international law and to the long suffering and abused Palestinian people. I should say that I speak on behalf of the Gaza People's Tribunal that will hold a final session on the Gaza genocide in Istanbul on October 23rd to 26th. And I serve as president of that tribunal, and we are very much encouraged by the UK Gaza Tribunal, which places for the first time in a proper emphasis on the complicity of a major liberal democratic country. I cannot overstate the importance of such an undertaking, because without that complicity, Israel could not have done what it is doing. And of course, with the complicity of others, most notably my own shameful government, the US, which has continued without ambiguity or ambivalence to give unconditional support and to act beyond mere complicity to be an agent of the destructive policies being carried out in Gaza to this day. And I would also emphasize at the outset that this is a moment of dire emergency for the people of Gaza who are threatened with mass starvation as a consequence of a famine that has been belatedly but officially declared by the International Bureau that is very cautious about reaching such a conclusion. If the world waits much longer, it will have waited too long, and history will remember the failure to meet this salient crisis of our time, a crisis that not only has compromised the integrity of governments professing to be sharing the values of the United Nations, including respect for international law, but have gone to extreme extent to discredit recourse by the Palestinian representatives to the UN and internationally to take advantage of the peaceful procedures provided by the International Court of Justice and the International Criminal Court to interpret and declare authoritatively international law. What they can't do, and were never designed or given the capability to do, is to enforce international law when the Security Council of the UN is paralyzed by its veto. So it isn't international law that has failed, but it's the political will of the supportive countries to this pattern of genocide that has been unfolding before the eyes and ears of the world for almost 2 years. A transparent, daily ordeal of atrocities that is denied its reality as well as enabling it to continue. And nothing reveals that denial more than the diplomatic support that has been given to Israel up to this day by treating it as a normal state. That is a form of diplomatic complicity, considering the criminality of its actions and its failure to comply with very clear, authoritative judgments and decisions by the highest international courts in near unanimous decisions. This is a shocking reality, and it's been obscured by various diplomatic ploys, most shockingly by the United States' denial of the right of Palestinians to come and attend the General Assembly session because they've resorted to what they call lawfare, which is actually one of the leading principles of international society and the UN mandating states to resolve their disputes by peaceful means. And this kind of diplomatic support that continues to occur, not only materially, by the failure to condemn Israel for what it has been doing and to take concrete steps in light of that condemnation. And we must observe that all of the anti-colonial wars have been determined not by the battlefields where weapons are used, but by the diplomatic dynamics of legitimacy and illegitimacy. As long as Israel can have the legitimacy of a sovereign member of the UN without being suspended for its non-compliance with UN directives, there is no effective means to curtail its policies. So one would hope that not only would this tribunal in the United Kingdom serve to show the repudiation of complicity, but to have an effect that achieves that disaffiliation on a diplomatic level as well as on the material levels of financial and arms support. And one hopes this is an example that other complicit countries will follow, because we've reached the point where the governments of the West have shown the failure to uphold the most vital elements of international law, and they have been complicit in the violation of those vital elements. And the UN has been paralyzed as a consequence, and there has not been an alternative than turning to the people of the world and allowing their moral outrage to have a political consequence. And first of all, within those countries that have been complicit. And hopefully these kinds of procedures will initiate a new sense of responsible statecraft that serves the public good as well as the national interest, and serves as, above all, to prevent genocide, crimes against humanity, and crimes of war from occurring at this critical historic juncture. Let me stop.
Just ask one small question.
Thank you so much,
Richard-
Professor.
Richard, we have time limitations, so if you could just answer closely, do you see any resemblance between the kind of political deception and cover-up that people have been describing here today and the Pentagon Papers in the United States?
That's an intriguing question, and it is certainly, there's maybe not a resemblance, but an analogous process of not wanting the citizenry to know what is really happening. The sanctioning of Francesca Albanese, the unpaid special rapporteur of the UN, for her truth-telling reports on the colonial settler genocide that have been occurring is an example of privileging lies and punishing truth. And the Israeli killing of journalists through targeted means is a further emphasis by those that are carrying out these crimes on the need to suppress truth so the people won't act. And the media, too, have been complicit. The mainstream media have been integral to allowing complicit governments to hide the truth.
Very quickly, Richard, thank you for your evidence. One question. In your experience, which goes back a long way, previous genocides in Cambodia, Darfur, Rwanda, Burundi, and so on, have always met with pretty well universal condemnation of the forces that have committed those genocides. Can you remember an occasion when the ICJ has found a commission of genocide and the US government and others have not condemned the perpetrators of it?
Not in those clear terms. I suppose you could make a case that the Serbian genocide at Srebrenica is the closest example. But I would say in general that even though one's disappointed with the absence of condemnation, the international system has never handled genocide in an appropriate way, including the Holocaust, which never became a source of international action until Germany attacked its neighbors.
Thank you very much, Professor Falk. For the interest of time, we have to move to our next speaker, who is Rami Khayal, an organizer with the Palestine Youth Movement, PYM, a transnational independent grassroots movement of Arab youth in exile, organizing for the liberation of Palestine from Israeli occupation and confronting Zionism. He has worked on and supported a number of campaigns, blockading logistics offices, arms factories, with organizations such as Workers for Free Palestine, and has worked on PYM's Masks of Maersk campaign, which calls for logistics company Maersk to seize the transportation of military cargo supporting the Israeli genocide of Gaza, including components transported to the US for manufacture to be later shipped to Israel. Rami, the floor is yours.
Thank you very much. I'd first like to extend our thanks to the Tribunal for inviting us to provide our evidence today. In May of this year, the Palestinian Youth Movement, in partnership with Workers for a Free Palestine and Progressive International, published a report exposing British arms exports to Israel covering a period of October 2023 to March 2025. During this period, thousands of military goods were sent from Britain to Israel, and the evidence suggests that these shipments are ongoing. David Lammy stated in Parliament that much of what we send to Israel is defensive in nature. It is not what we describe routinely as arms. However, our research shows that since October 2023, in fact, Britain has sent thousands of military goods to Israel, which are defined as arms and ammunition. Israeli Tax Authority, the ITA, data indicates that 14 shipments of military items were sent from Britain to Israel since October 2023. And from this data, there are 11 shipments by air to Ben Gurion Airport and 1 maritime delivery to Haifa, carrying over 160,000 military items. This includes a shipment of 150,000 bullets to Israel in October 2023. However, most of these shipments occurred after the British Labour government's suspension of around 30 arms export licenses to Israel in September 2024. The data shows that Britain has sent 8,630 separate munitions since the suspension took effect, all in the category of bombs, grenades, torpedoes, mines, missiles, and similar munitions of war and parts thereof. In addition to weapons and ammunition, evidence shows 6 shipments of 299 items, which the ITA identifies as tanks and other armoured fighting vehicles, motorised, whether or not fitted with weapons and parts of such vehicles. ITA import records include shipments from Britain to Israel, while falling under custom codes not explicitly classified as military, still warrant highlighting and examination. They show 4 shipments of 340 items in the category of parts and accessories for pistols and revolvers, 2 shipments of 27 items in the category of parts and accessories of shotguns or rifles. Yesterday, fellow contributors to this tribunal spoke on aircraft parts, particularly in relation to the F-35. As a part of our research, we reviewed the frequency of shipments of aircraft items from Britain to Israel. Considering that the majority of military export licenses issued over at least the past 5 years have been aircraft parts, we would have expected an observable decrease following the license suspension in September 2024. In fact, following statistical analysis, we found that there were an increase in the number of shipments following suspension. While we cannot conclusively say that these shipments are of military aircraft or military aircraft components, nevertheless, these trends are concerning. The British government must release transparent and complete licensing and export data to clarify the nature of these goods, and a full investigation of these shipments is required. We're all aware of the exemption made to F-35 components. The only amendment made to the open general export license being that components can no longer be sent directly to Israel. However, utilising research by Declassified UK and the Ditch as a grounding, we were able to identify the established pattern of the use of courier shipments for small shipments of F-35 spare parts. We found that this pattern continued after September 2024 and was ongoing as of March 2025. However, once again, it cannot be confirmed whether they are for the maintenance and repair of the current Israeli F-35I fleet at Nevatim Air Base, as in the Declassified UK report, or are intermediary components for eventual re-export to the global F-35 supply chain. In either case, these parts can and do ultimately end up in Israeli F-35s. Once again, the British government must release complete details of these shipments. The British government has stated before that British military exports make up a small percentage of Israeli military imports in comparison to the likes of the US. However, no matter how small the percentage, military components and goods manufactured in Britain are being utilized by the Israeli military to conduct a genocide in Gaza. We have seen war crime after war crime in this genocide. The targeting of hospitals, of schools, the massacres of displaced Palestinians, the targeting of journalists, of medical personnel. These acts of war crimes and ultimately genocide are being carried out with material either manufactured in Britain and directly exported to Israel, or with components manufactured here and exported for assembly elsewhere, such as the US. Britain has played and continues to play a key role in this genocide beyond complicity. It has provided the means to carry it out. In the face of political and public opposition to Israel's genocide in Gaza, the Labour government has sought to conceal the extent of British military material being used by the Israeli military in conducting this genocide, misleading the people it is meant to represent and the MPs in the House of Commons. The British government's response to the Israeli genocide in Gaza should be unequivocal. At the bare minimum, international law should be upheld. War criminals like Israel's President Isaac Herzog should not be welcomed by Labour government ministers. He should be tried and sentenced in The Hague. The people of Gaza deserve unfettered entry of aid, and they deserve to receive it in a dignified manner. As of today, over 2,000 Palestinians have been killed seeking food and medicine for themselves and their loved ones. In order for this horrific daily murder of dozens of Palestinians in Gaza to end, an immediate, full, two-way arms embargo on Israel must be implemented. History will not look kindly upon those who have appeased genocide or fascist Zionism. We should be proud that British popular will is on the right side of history. Now, the political powers that be must implement it. And thank you very much.
On the supply of parts to the F-35s, have you got evidence that the ones that have been put into the global supply chain do then end up in Israel?
Unfortunately, due to the nature of British sort of exports, it's very difficult for us personally to be able to track due to the custom codes that are used, due to the opaqueness of the British system of tracking export licenses, as an example. So it's very difficult for us to track exactly where the shipments go to in a public sort of setting. That information is unfortunately, like I say, quite opaque.
Ministers have claimed to me that it's impossible to follow through what actually happens to the components. My question is that from the time that there was any debate about arms control, this is going back more than 25 years, there was always an end-user certificate arrangement where everyone in this country that produced any weapon that was sold to another regime had to sign an end-user certificate to say where it would end up. The idea being that you could trace what happens to weapons as a result of that. What I've never understood is why the British government is unable to say what the end-user certificate system is now in relation to components of F-35 jets, because clearly if they make a component, say, of the undercarriage, they must know which country bought that undercarriage for their plane.
Unfortunately, when we were conducting our research into British arms exports, we were able to see end users for both direct and indirect shipments of arms. But from my understanding, for public knowledge, 10 to 15% of arms licenses aren't viewable. So we were unable to confirm through that where actually all the exports were going.
Do you know if the United States needs parts from the UK to run its F-35 program?
From my understanding, we produce 15% of the parts required for the F-35, and the UK is a key component into production of F-35.
That 15% also for the F-35s used by the United States, not by Israel? That's my question. If you don't know, you don't need to answer.
I'm not fully sure, but from what we have seen, the 15% that the UK manufactures is for all users of the F-35.
Okay, thank you.
If I may, do you have any knowledge if Herzog is the first senior Israeli official welcomed during the genocide, or has this been a more repetitive pattern of accepting people who might be held liable for war crimes and crimes against humanity as well as genocide?
Unfortunately, I don't know if there's been any other visits.
Yes. I just also wanted to ask, you mentioned munitions and landmines?
Yes, that's correct.
So how is this information accessible?
So we utilized Israeli tax authority data. So the only way we could view that these shipments were being made wasn't with the data provided by our government, but actually data provided by the Israeli government. We tried quite intensively to use British government data, but it proved extremely difficult to gauge any idea of what was being shipped to Israel.
Are we able to know which corporations would have produced that?
No.
That would be difficult.
We're unable to see which corporations produced that. We're unable to see where it came from in the UK. The only thing we were able to see is the sort of receiving port, so Ben Gurion Airport and Haifa Port.
So on this level, it is safe to say that even the Israeli government was more transparent about these shipments than the British government.
Oh yes, 100%. The British government likes to claim that we have the most transparent licensing system in the world, but comparatively, in say like the US, you're able to track a shipment, what ship it's on, where it's coming from, what's inside the container, and the end port. Whereas in Britain, that is not something that we can do, which is why it's proven so difficult to track arms exports.
So our level of transparency is much lower than what the government would like us to believe.
Yes, 100%. And this has been raised before in the past.
Thank you.
Are there any other countries in Europe that have a similarly opaque system to Britain? Do you know?
I wouldn't know that off the top of my head, no.
Thank you very much, Rami.
Thank you very much for having me.
When will we meet?
No. That's the end of this session. So we'll resume, unless the team over there tell me differently, we'll resume at 1:15. As a positive from the deck. So we'll resume at 1:15 for the final session today. And thank you very much to all our witnesses this morning. There's been some very, very well-researched and very powerful testimonies given this morning. And I want to say, on behalf of the three of us, thank you very much to all those that have come and given evidence today. It's been quite a moving experience just listening to it. Adjourn till 1:15. If we can now start for the last session of the Gaza Tribunal, I just want to read a statement that Medical Aid for Palestinians have asked me to make to put on record. Medical Aid for Palestine remains a registered humanitarian organisation in Gaza and the West Bank, holding valid registration with the Palestinian Authority. Our teams continue to deliver MAP's largest ever humanitarian response, working through trusted partners to ensure that medical and humanitarian aid reaches those who need it most, despite severe Israeli restrictions. That's the end of the statement. We're now into the last session of evidence we're taking, and then there will be some concluding remarks from the three of us, which will not be the last word on everything, but there will be our initial thoughts about what we've heard over the past 2 days. The first person I want to invite to speak is Guillaume Long, who is a former Foreign Minister of Ecuador, also Ecuador's representative at the UN in Geneva, and currently very much involved with Progressive International, and is one of the key advisors to the Hague Group of Nations, which are holding Israel to account internationally by their adherence to the decisions made of the International Court of Justice and the International Criminal Court. And his evidence today, Guillaume's evidence, is going to be particularly pertinent to the question of international law and genocide and the way in which governments around the world handle these kind of issues when they come up. So I'm absolutely looking forward to the evidence you'll present to us this afternoon. Guillaume, thank you very much for coming, and the floor is yours.
Thank you very much, Jeremy. I hope you can hear me all. I'm sorry not to be there in person. Members of the tribunal, I appear today, as Jeremy said, in my capacity as advisor to the Hague Group, as diplomatic advisor to the Hague Group, which is a coalition of states which launched in January of this year to uphold international law in Palestine. So that's as simple as that. And today I wish to show in 6 clear commitments the gulf between the obligations of states under international law, the actions of a number of governments that have begun to enforce said international law, and the record of the United Kingdom. Now, in July of this year, a couple of months ago, 31 states attended a high-level diplomatic meeting convened in Bogota, in Colombia, by Colombia and South Africa, the 2 co-chairs of the Hague Group, on the need to enforce measures, concrete measures, to put an end to the genocide in Gaza. The UK government was, of course, invited to this conference, but to my knowledge, never even responded to the invitation, let alone made itself present. The main objective of the Hague Group is to implement, again, concrete state measures in application of international law. Enough calling for, condemning, denouncing. What can states do in practice through clear national policies to enforce their obligations under international law? So the Bogota conference ended with a clear joint commitment on 6 collective measures, which we might call the Bogota measures, which provide concrete examples, I think, of the kinds of applications, the kinds of enforcement of international law that the United Kingdom could easily and should absolutely be carrying out in the context of Israel's crimes under international law. So let me go through the 6 Bogota measures one by one, starting with the Bogota Conference's commitment number 1, which prevents, and I quote, the provision of or transfer of arms, munitions, military fuel, related military equipment, and dual-use items to Israel. Now, several states have taken measures to fulfill this obligation. Indeed, some of them have started doing this long before the Bogota conference. In May 2024, Turkey, one of the signatories of the Bogota measures, halted exports in 54 product categories to Israel. As early as 2023, a few weeks after October 7th, Spain, which is one of the 4 European countries that did show up in Bogota and was present at the Bogota conference convened by the Hague Group, Spain announced that no new licenses for arms exports would be authorized. Arms exports to Israel, of course. And it then moved to suspend existing authorizations of arms exports to Israel. But also in the Netherlands, and this is admittedly not an executive decision, but we have a court of appeal which has ordered the government to hold exports of F-35 parts to Israel. This was in February 2024, of course, due to the risk of violations to international humanitarian law. This is extremely relevant to the UK, as we all know. Now, beyond the issue of exports, several other states have also started to significantly scale down their military ties with Israel. There are a number of examples. I can't give examples for every single measure, every single policy, but Brazil has finally cancelled its deal with the Israeli corporation Elbit Systems at the start of 2025. Chile has significantly cut security and defense ties with Israel in a number of ways and has put military imports significantly under review amongst a number of other states. In contrast, throughout 2024, the UK government refused to impose a comprehensive arms embargo and has continued in 2025 to issue licenses for weapons components destined for Israel. Weapons which we know, of course, are being used in the genocide in Gaza. So that's for measure number 1. Now, the Hague Group's Bogota Conference's commitment number 2 prevents, and I quote, the transit, docking, and servicing of vessels at any port, in all cases where there is a clear risk of the vessel being used to carry arms, munitions, military fuel, related military equipment, and dual-use items to Israel. Again, several states are already fulfilling this legal obligation. Malaysia, which is one of the key Hague Group founders, announced in December 2023 a nationwide ban on Israeli-flagged vessels and on any ships bound for Israel from docking at Malaysian ports. Namibia, also a founder of the Hague Group, revoked permission in August 2024 for the MV Catherine, this is a big case, to dock in Walvis Bay over suspicions it carried explosives destined for Israel. The Spanish government blocked the Mariana Danica, a ship, in May 2024, which was suspected of carrying arms to Israel, and it blocked it from docking at all its Spanish ports. In contrast, the UK has not barred Israeli-bound arms shipments from its ports. Vessels continue to pass freely through UK ports with equipment that we know is being used in the perpetration of war crimes. The Bogota Conference's commitment number 3 prevents the carriage. So we have arms embargo, we have ports, but we also have this measure number 3, which is very important, which is the carriage of arms, munitions, military fuel, related military equipment, and dual-use items to Israel on vessels bearing countries' flags. This ensures full accountability, including deflagging for non-compliance with this prohibition. Again, several states have started to fulfill that obligation. Malaysia, as early as December 2023, explicitly banned Israel-bound ships from operating under its flag or through its ports. In May, recently, Antigua and Barbuda issued a directive to ban all its ships sailing under its flags to carry weapons to the conflict zone and confirmed that vessels in breach of these prohibitions were liable to be detained and that it would deflag the vessel and take all sorts of other legal actions. In contrast, the United Kingdom has issued no prohibition on UK-flagged ships carrying arms or fuel to Israel and no deflagging measures against vessels complicit in violations of international law. The Bogota Conference's commitment number 4 is a review of all public contracts to prevent public institutions, state institutions, and funds from supporting Israel's illegal occupation of the Palestinian territory and entrenching its unlawful presence there. Again, several states have started to take measures to fulfill this obligation. Spain again suspended arms authorization and introduced administrative measures, public measures across its ministries to prevent public institutions from supporting Israel's unlawful occupation. Importantly, Norway, just recently, and Norway was present at the Bogota Conference. It was one of the 4 European states present in Colombia. Spain, Norway, Slovenia, and Ireland were the 4 European states present at the Bogota Conference. And Norway, just now, in August 2025, under pressure, admittedly from its unions, convened. The unions took a series of measures, and Norway was forced to. Norway has a huge sovereign wealth fund, a $2 trillion sovereign wealth fund, which has had some significant investments in Israel and with Israeli corporations. And Norway just announced it was terminating all contracts with asset managers handling its Israeli investments and has divested parts of its portfolio, even if admittedly still much more needs done. But it's a very important step, first step taken by Norway. And we just saw this week Belgium, which is the non-Hague Group or Bogota measures country, if you like. We hope Belgium joins promptly, and it's already confirmed its presence at an upcoming meeting in New York. But Belgium announced a list of 12 measures this week, including a review of all its public procurement policies with Israeli companies. Again, in contrast, in the United Kingdom, instead of excluding complicit companies from public contracts, the Conservative government passed legislation in Parliament in June 2023 to restrict public bodies, local authorities, and public universities from boycotting companies involved in Israel's illegal occupation. This restriction, which was passed under the previous government, has not been reversed by the Labour government, despite the fact that we face now a genocide. Commitment number 5, to ensure accountability for the most serious crimes under international law through robust, impartial and independent investigations and prosecutions at national or international levels to ensure justice for all victims and the prevention of future crimes. Again, several states have started to fulfill these accountability obligations. In December 2023, South Africa famously filed its case against Israel at the International Court of Justice, winning provisional measures in January 2024 to protect the Palestinian people from genocide. In January 2024, Chile and Mexico referred situation in Palestine to the ICC, obliging the prosecutor to act on the gravest crimes. In contrast, and despite overwhelming evidence, the UK has not initiated a single domestic investigation or prosecution into war crimes in Gaza. Instead, it continues to license arms and defend Israel politically. And the Bogota Conference's last commitment, commitment number 6, to support universal jurisdiction mandates as and where applicable in national legal frameworks and judiciaries to ensure justice for victims of international crimes committed in the occupied Palestinian territory. Several states, again, are taking measures to fulfill this obligation. In July 2025, Spain's Audiencia Nacional opened a universal jurisdiction investigation into attacks on a humanitarian flotilla bound for Gaza. South Africa, again reaffirming its Rome Statute obligations, welcomed the ICC arrest warrants and not unlike a number of other states, prepared domestic law to cooperate with prosecutions. In contrast, the UK has not exercised its universal jurisdiction powers to pursue perpetrators of crimes in Gaza. The UK has chosen instead political convenience over legal obligations. Members of the tribunal, the UK is clearly in breach of its obligations under international law, choosing instead to protect its arms industry, its shipping interests, its political alliances over the lives of Palestinians and its commitments under international law. Other governments have shown the law must and can be enforced through arms embargoes, port bans, court rulings, public procurement policies, and international litigation. The law exists, the precedents exist, the mechanisms exist. The UK has eagerly applied an array of measures against Russia through comprehensive sanctions, export controls, asset freezes, and targeted trade measures, against China through human rights sanctions and technology restrictions, against Myanmar, again, through sanctions and export restrictions on military supplies, against Belarus, against Syria, and against a number of other states through financial and trade sanctions, designation lists, etc. But not against Israel, a state currently committing genocide. This hypocrisy, these double standards, are unacceptable and put into question the very sincerity of the British state's avowed commitments to norms, institutions, and international law. I thank you.
Should I take a question? Thank you very much. Questions?
Yes. Thank you very much for that testimony. In your opinion, I mean, the British government and the UK likes to present itself as one of the architects of the post-World War II legal order that includes both international humanitarian law and the Geneva Convention on Genocide. In your opinion, what is the effect of the UK government completely ignoring this legal system in relation to Gaza and Israel's genocide in Gaza? How will that affect the legal system itself, or will it affect it?
I mean, I think it has three terrible consequences, effects, if you like. The first is, of course, on the Palestinian people who are currently being victims of terrible war crimes. And the United Kingdom, as a powerful country in the international system, one of 5 permanent members of the Security Council, which is also a wealthy state with a lot of sovereign capacity to have an impact on the way the international system functions. The United Kingdom could do a lot more to save lives and to protect the inalienable rights of the Palestinian people. That's the first effect. The genocide goes on, and the United Kingdom is, in many regards, complicit. The second impact is, of course, an impact on international law. And the Hague Group is, of course, first and foremost, a group which defends the human rights of human beings, of Palestinians in Gaza and in Palestine. But it is, of course, indirectly, a group which stands in defense of international law, of norms, of multilateralism, of an international system based on the rule of law, on justice and democracy. And what the United Kingdom is doing by ignoring its obligations under international law is contributing to the erosion of international law, to the erosion of the global social contract. And that's a very, very serious, I was going to say crime, yes, almost a very, it's particularly given, again, the UK's very important responsibilities as a permanent member of of the UN Security Council and as a powerful member of the international community, if you like. And I think the last way that it impacts, it has a negative impact, is on the UK's own credibility. The United Kingdom is shooting itself in the foot. It's calls for the respect for human rights in some contexts, but not in others. It's clear double standards. Its approach towards its foes being so different towards the approach towards its friends really lifts the veil and exposes a tremendous amount of hypocrisy, which actually recalls colonial times and colonial behavior, and a tremendous amount of arrogance, which I think hampers the UK's prestige on the world stage, and also actually hampers, in very sort of practical terms, the UK's core interests. I've been engaging with a lot of countries around the world, and the countries that have been complicit in Israel's crimes, I don't think are going to be easily forgiven or forgotten, let alone what the history pages will have to say about that.
Okay, last question from me. Thank you very much for what you've just said. You pointed out about the Bogota Convention and the discussion that went on there. Could you perhaps explain, so we can get it clear in our analysis of this two-day hearing, the role of the Hague Group, and above all, what the aspirations of the Hague Group now are on the global stage?
Absolutely. The Hague Group was created, I think, because of growing frustration, particularly after 2024, which was a year where there was a lot of international law that was being created and voted on. There was a very important advisory opinion of the International Court of Justice in July 2024, last year, which established clear state obligations, and then a historic vote in United Nations General Assembly in September of 2024, which again established clear obligations, binding obligations for states. And yet, when the Hague Group founding members met for the first time in January, they came to the conclusion that these binding mechanisms were not being respected, that states were not enforcing what they'd voted for, and were in violations of their obligations under international law. And so the idea behind the Hague Group is not to create more bodies of international law. There are other blocks of states and instances and multilateral fora in which this is happening and should continue to happen. The idea behind the Hague Group is to enforce our obligations, to apply international law, so that international law doesn't become a dead letter, so that multilateralism doesn't become something we say but do not act upon. And so the Hague Group is synonymous with measures. We, the members of the Hague Group, will apply measures in our domestic legislation. We will apply policies in order to be in compliance with international law, and of course put an end to the genocide in Gaza. 9 states launched the Hague Group in January. More and more states have shown interest. In Bogota in July, 31 states joined the Bogota conference convened by the Hague Group, and a number of states, and more increasing number of states, are adhering to the Bogota measures, which I've just listed, these 6 measures which have fundamentally to do with arms transfers or arms embargo, the docking of ships, shipping, very importantly, public investments in occupied territories, and particularly when it is in complicity with Israel's genocide in Gaza, and of course accountability with war crimes and genocide, which is also one of the pillars of the Hague Group, both in its inaugural measures in January and in the 6 Bogota measures I've just announced now. It's all about concrete action. States can and should take concrete actions. No more calling for condemning, denouncing. We've done a lot of that. It's time to act, and that's the Hague Group's key and core message.
Thank you very, very much for the evidence you've given us today. It'll be very helpful in drawing up our report.
My pleasure. Thank you very much.
Thank you. Our next speaker or witness is Dr. Raz Segal, who is Associate Professor of Holocaust and Genocide Studies and Endowed Professor in the Study of Modern Genocide of Stockton University, New Jersey. His scholarship focuses on modern genocide, the Holocaust, and state violence. He has published extensively, including on comparative genocide and mass violence, and is the editor at the Journal of Genocide Research. He's also, I would add, one of the establishers of a network of genocide scholars with several hundred genocide scholars on this in this group, which he and a few others have been leading over the past half year. Thank you, Raz. The floor is yours.
Hello, everyone. Can you hear me?
Yes, we can hear you loud and clear.
Terrific. Just a second. I'll just share my presentation. Okay. This is okay?
Yes.
Okay. Thank you so much. There's a consensus today that the UN figures for the number of Palestinians that Israel has killed in its genocide in Gaza since October 2023 represent less than half of the actual number, which therefore is around 120,000. There's also consensus that the ratio of indirect death to direct death in such situations due to famine and hunger and disease ranges from 3-to-1 to 15-to-1. Israel's bombing of Gaza is the most intense bombing of an area in the 21st century. So the ratio in this case is probably higher rather than lower. But even if we take the lowest, 3-to-1, we reach a horrific conclusion that Israel has killed directly around 120,000 Palestinians in Gaza so far and has created the conditions for the painful death of around 360,000 more. Almost 500,000 people out of a population of nearly 2.3 million, more than 20%. Israel's brutal war on Palestinians in the last 23 months has furthermore left well over 150,000 with serious injuries, in many cases maimed, with countless others who suffer from trauma that will accompany them if they survive the continued carnage for the rest of their lives. It will also likely shape the lives of their children, because for the people that perpetrators of genocide target, genocide in a way never ends. In the short time I have, I would like to address how those who today continue to deny this genocide argue that genocide needs to look like the Holocaust, and that if Israel had wanted to perpetrate genocide against Palestinians, it would have killed far more Palestinians by now, because the Nazis killed as many Jews as they could. But before I turn to my arguments and to the evidence, I'd like to say, as a scholar of the Holocaust, as a scholar of Jewish history, as a person who grew up with grandparents who were Holocaust survivors, a key lesson of the Holocaust, which Holocaust scholars have been teaching students for decades now, is to listen to the people who face genocide, to Jews who had faced the violence of the Nazis and their allies. The ethics of Holocaust memory, and by implication of genocide prevention, is not to take the perspective of extremely violent states as our point of departure, but to place front and center the voices, the knowledge, the perspectives of the people targeted by such states. And Palestinians understood exactly what they were facing from the very beginning of this Israeli attack on Gaza in October 2023, which was, as we remember, one of the most brutal months of Israel's genocide so far. I want to give just a couple examples. S, a community worker, started sending WhatsApp messages from Gaza to friends on October 10th, 2023, with only 3 words in the first message: terror, terror, terror. On October 15th, he wrote, "They are killing families, whole families. I want to forget what I saw. You can't imagine, beyond reality." Poet Khiba Abu Nada wrote on 9th of October 2023 that Israel's attack this time follows, quote, "no pattern. Everything is being bombed. Gaza from the north to the south being bombed in a chaotic, catastrophic manner. Mass butchery, senseless assassination of everything." An Israeli airstrike killed her 11 days later. And on 12th of October 2023, a journalist and translator, wrote in a WhatsApp message, "Where is the West? Where are these human rights they preach? Where is international law? This is genocide, and it should be immediately stopped." As I noted, those who continue to deny the Gaza genocide, especially people in positions of power who would like to find any way not to fulfill the moral and the legal obligation of genocide prevention, they imagine that genocide needs to look like the Holocaust. This follows from the idea that the Holocaust is a unique event in human history. This uniqueness bestows uniqueness also on Israel, perceived in this narrative as the state of Holocaust survivors, suggesting that it cannot perpetrate any crime under international law, let alone genocide. This is a key source of the impunity that Israel enjoys in the international political and legal system. But the Holocaust did not begin with the Nazis killing as many Jews as they could. Rather, the Nazis decided to do so quite late in the war, in spring 1942, and only once it became clear to them that due to significant German military setbacks, they would not be able to realize their goal of forcibly removing all Jews from the expanding German Empire. In other words, the decision to move to systematic mass murder of all Jews within German reach followed the failure of what we call today ethnic cleansing, but both figured within the process of Nazi genocide. Now, consider those unashamed calls by Israeli leaders immediately after October 7th and still ongoing to remove all Palestinians from Gaza. Earlier examples include Israeli government designs of forcing all Palestinians from Gaza to the Sinai Desert in Egypt, as laid out in a document prepared by the Israeli Intelligence Ministry on 13th of October. It bears mentioning here that forced displacement to deserts has characterized a number of modern genocides, including the German destruction of the Herero and Nama in Southwest Africa in the early 20th century, and the Armenian genocide. But there is more, much more. On 11th of November 2023, Israeli cabinet member and minister Avi Dichter described in an Israeli radio interview Israel's attack on Gaza as the Gaza Nakba. Israel's former military chief, Aharon Khalifa, commented in recent months that, quote, "the fact that there are already 50,000 dead in Gaza is necessary and required for future generations. It does not matter if they are children. They need a Nakba every now and then to feel the price." These are not lone voices. In October 2024, Israeli settler leaders, accompanied by Israeli members of the Knesset, the Israeli parliament, and government ministers, gathered just outside the Gaza Strip to call for the removal of all Palestinians from it, its annexation to Israel, and its settlement by Jews. Most recently, on 24th of July, 2025, Israeli Heritage Minister Amichai Eliyahu said in an interview on the Jewish ultra-Orthodox radio station Kol Barama that, quote, all Gaza will be Jewish. The government is pushing to wipe out Gaza. Thank God we are wiping out this evil. We are wiping out the population that has been educated on Mein Kampf. And back in March 2025, when Israel broke the ceasefire, Israeli War Minister Israel Katz had this to say. The people of Gaza, he began, this is your last warning. The attack of the Israeli Air Force against Hamas terrorists was the only first step. The rest will be far more difficult, and you will pay the full price. Unless all Israeli hostages are released and Hamas expelled from Gaza, Israel will act with force that you have never seen. Take the advice of the US president. Return the hostages and expel Hamas so that other possibilities open up for you, including leaving the Gaza Strip to other places in the world for those who would want that. The alternative, he concluded, is devastation and utter destruction. Now, these clear expressions of genocidal intent by the people who determine Israel's policies and military actions undermine the claim by Israel and its supporters that Israel's attack on Gaza only targets Hamas or seeks to free Israeli hostages. Israel's attack on Gaza, rather, uses forced displacement as an integral part of a process of genocide, a war against, quote, the people of Gaza, as Katz put it in a message that echoes what Israeli President Yitzhak Herzog said clearly days into Israel's attack in October 2023, and I quote Herzog here, it is an entire nation out there that is responsible, and he was referring to the Hamas attack on Israel on October 7th. Therefore, today, in Katz's eyes, it makes sense that, quote, the people of Gaza should pay the full price, and that what awaits them, in his eyes, is devastation and utter destruction. When a state envisions forcibly displacing millions of people, it is, in effect, as the history of 20th century genocide shows us, it is envisioning their demise as a people, including, as I noted, in the case of the Holocaust. Forced displacement has also always been a key element of Israeli violence against Palestinians, from the 1948 Nakba and ongoing until today, aiming to realize Zionist settler colonialism, the greater Israel vision of obtaining maximum territory with as few Palestinians as possible. Indeed, elsewhere in Palestine, in the course of the Gaza genocide, the Israeli army, together with extremely violent Jewish settler militias, is moving forward with lightning speed in the expulsion of thousands of Palestinians and the destruction of dozens of communities in the Jordan Valley, which comprises about a third of the occupied West Bank and is considered its breadbasket. What future awaits forcibly displaced Palestinians in ever-shrinking areas in the occupied West Bank, deprived of their lands and sources of livelihood, exposed to increasingly more wild attacks by Jewish settlers, and under the daily oppression of the Israel genocide state? It is urgent to stop the Gaza genocide, and it is urgent to prevent the escalation of Israeli mass violence in the West Bank into full-fledged genocidal violence. Myanmar's attack on Rohingya Muslims is another example of forced displacement that figures in a process of genocide. And like the case of South Africa against Israel, now in front of the International Court of Justice, another global South country, the Gambia, filed in 2019 a genocide charge against Myanmar at the ICJ. A joint declaration submitted in support of the Gambia by several Western states, including the UK, argues the following, and I quote, in assessing whether a specific act constitutes an underlying act of genocide, if the act is committed against children, its particular impact on children must be taken into account. The declarants propose to make submissions as to the construction that ought to be given to Article 2 of the Genocide Convention in relation to act committed against children. The declarants submit that when applied to children, the term, quote, serious bodily or mental harm ought to be interpreted in light of the distinctive needs and vulnerabilities of children. In particular, the declarants submit that there is a lower threshold for serious bodily or mental harm when the victim is a child. More specifically, the declarants submit that, as with Article 2B of the Genocide Convention, the conditions of life that will bring about the physical destruction of members of a group will depend on the characteristics of members of the group. When considering the deprivation of food or the imposition of a subsistence diet, it would be relevant to consider that the amount of food that would ultimately lead to the death of an adult is different than that which would lead to the death of a child. Similarly, the medical needs of children are different than those of adults, and account needs to be taken of those differences in considering whether the absence of particular medical services amounts to the imposition of conditions of life that would bring about the destruction of specific members of the group. Now, the Myanmar state and its ongoing genocide against Rohingya Muslims for more than a decade now has killed thousands of children, and around half of the 1 million Rohingya Muslim refugees who have fled to neighboring Bangladesh are children. Much to the surprise of the Western states that submitted it, including, again, the UK, the Joint Declaration's description of the dire conditions of Rohingya children, both those who remain in Myanmar and those who have fled, applies equally to Palestinian children in Gaza. In both cases, children have suffered and continue to suffer, quote, serious bodily and mental harm and conditions of life that would bring about their destruction due to unceasing state violence and lack of food and medical services. According to the UN, 1 million Palestinian children in Gaza are in need of mental health and psychosocial support. Around 132,000 children between the ages of 6 to 59 months are projected to suffer from acute malnutrition through summer 2026, including over 40,000 severe cases. Israel has also killed so far over 18,000 Palestinian children in Gaza. The actual number is higher, we know, but even these unfathomable figures demonstrate Israel's systematic attack on Palestinian lives and futures, as embodied in children, an attack that began well before October 2023, and not only in Gaza. But Palestinian scholar Nadia Shalom-Kevorkian has described and analyzed as, quote, unchilding. What I presented and what others have presented to this tribunal is just a little bit of the mountain of evidence for genocide in Israel's attack on Gaza. The evidence is so clear that a large number of genocide scholars now recognize this as a case of genocide. Indeed, the largest professional association in the field, the International Association of Genocide Scholars, has published a statement a few days ago recognizing the genocide, following a vote among the members that passed with a majority of nearly 85%. It is now clear to many people, many human rights organizations, and a growing number of states that this is a genocide according to international law criteria and according to sociological and historical criteria. But it was clear very early on, as I mentioned, to Palestinians on the ground. And the UK government, along with many other governments around the world, is not, are not, and have never listened to Palestinians. It is now very late, but people with power to stop this genocide, including the UK government, must finally shift from supporting the Israeli state perpetrating this genocide to fulfilling their legal and their moral obligation to the people facing this genocide, who demand to stop it, who demand self-determination, accountability, truth, and justice. Free Palestine.
Thank you very much, Raz.
Thank you very much, Raz. I have a quick question as to whether or not it has come to your attention of any British officials who might have engaged in the incitement of genocide or otherwise endorsement of statements that were said by Israeli officials, particularly or in general.
I don't have any examples for that specifically on, at this moment.
So another question is, based on historical evidence as well as the current mode of argumentation, how is the "what about Hamas" argument been weaponized to justify the genocide or the mass civilian toll?
Well, I think that it's clear, as I've presented, the evidence shows that Israel's attack on Gaza does not, merely aim to target Hamas or to free Israeli hostages, for that matter, but there's a clear intent that has been expressed over and over again, dozens and dozens of times, by people with command authority in international law, state leaders, senior army officers, to destroy Palestinians in Gaza as such, to use the language of the UN Genocide Convention. We also have, because Israel and Israeli leaders, and as I've shown, senior military officers are telling us that they want to remove all the Palestinians from Gaza, and they continue to tell this to us. And because we see this dynamic, as I've explained, of forced displacement figuring in a process of genocide, right? A population that the perpetrators want to get rid of, but there is nowhere that they can go. And they're telling us constantly that they want to destroy them, that they see them as enemies, that they see them in dehumanizing terms as human animals, in dehumanizing terms as all Nazis, right? Population educated on Mein Kampf, and so on and so forth. Again, in dozens and dozens and dozens of expressions, and still ongoing. So we know that there's a clear intent that is well beyond just targeting Hamas, that is well beyond freeing Israeli hostages. And the intent is, as I said, to bring about the demise, the destruction of Palestinians in Gaza as such. And it's, I think, worth mentioning that the fact that Israel says that it wants to target Hamas, it's very possible in international law that there would be an intent to target Hamas and intent to destroy the Palestinians in Gaza as such, or an intent to destroy the Palestinians in Gaza as such, as an integral part of Israel's plan to destroy Hamas. Either way, this makes it a very clear-cut case, now 23 months into it, of genocide. The Hamas, the argument of we're targeting Hamas does not fit the evidence. In other words, simply does not fit the evidence.
Thank you.
Raz, thank you very much for your statement and the evidence you put forward. Question which I think is on many people's minds. In your experience of studying the Genocide Convention and the effects of genocide around the world, how far does the culpability go? Does it extend, obviously, to those that directly commit the crime, but does it extend to all aspects of the government that's occasioned the crime? And does it also extend to those that have continued to supply the wherewithal to continue to commit the crime, such as arms suppliers? And what evidence is there in the past of prosecutions that have been successful on this?
Well, I think that, as we know, the Genocide Convention also includes other crimes. There's incitement to genocide, and we've seen the Israeli media, for instance, mainstream media, has incited for genocide. Journalists openly, in an unashamed way, immediately following October 7th. And until today, this again also continues. I think this is in the hundreds of cases of incitement to genocide. We had a case, as is well known, in relation to the Rwanda genocide and the tribunals in that case, where media figures, in that case radio hosts, were put on trial for incitement to genocide. Then convention also includes the crime of complicity with genocide. And it's important to say that the convention is the Convention on the Prevention and Punishment of the Crime of Genocide, and prevention which really follows the Holocaust memory dictum of never again, right, is in the title of the convention. And the convention is activated actually not only when there's clearly genocide, but when there's a clear risk of genocide. And we've been in clear risk of genocide, the latest from January 2024 with the ICJ provisional measures ruling at the time that told everyone that it is plausible that Israel is perpetrating genocide in Gaza, and then ordered various things that, of course, the Israeli government has ignored completely. So complicity with genocide, then there's the legal obligation to prevent genocide that governments around the world that are party to the Genocide Convention, including the UK government, have failed to do. That's already very significant. But then there's also the obligation not to be complicit when there's clear risk and danger of genocide, which governments around the world, including the UK government, who have provided weapons to the Israeli government, have also been doing, being complicit in Israel's genocide in Gaza. And we know actually that this is a case that cannot have happened, it cannot have continued to happen for 23 months now without the support of Israel's Western allies, including the UK government. And so in a way, right, this genocide could have been stopped long ago. And it could have been stopped also by the UK government. And as long as these governments allow the genocide to continue, as long as they continue to transfer weapons to Israel, as long as they continue to provide diplomatic and economic support to Israel, they are absolutely complicit in Israel's genocide in Gaza.
Thank you very much. That's very helpful.
Les, one final question. You talked about intent, and the British government has been saying it's unclear to us what Israel's intentions are. And you showed again and again, and others have shown, that the intent is very clear. You've also said that the British government has condemned and denounced and been part of efforts to prevent genocide in other places around the world. In those other places, was there the enunciations and statements made by politicians, the kind of intentions of genocide, were they similar to the ones that Israel has made, or is Israel an outlier in this sense?
Well, as I've written in my piece in Jewish Currents in 13th of October 2023, Israel's genocide in Gaza was already in October 2023, actually, and certainly now. What I describe as a textbook case of genocide, in large part because of the clear and unashamed expressions of genocidal intent that we've seen immediately after October 7th, the crude dehumanization, as I mentioned, of Palestinians. We don't have this sort of expressions. I quoted Heritage Minister Amichai Eliyahu's continued description of all Palestinians in Gaza as Nazis, basically. His admission that the government, he's telling us, the government is working to wipe out Gaza. This is a minister in the Israeli government telling us this, right? Israel's war minister, Israel Katz, and I use war minister intentionally, right, in this case, Israel Katz, telling the Palestinians and the people of Gaza, he's turning to the people of Gaza, and he's telling them that if they don't leave, where to, right, what awaits them is devastation and utter destruction. We don't have these things in other cases because perpetrators of genocide don't really usually go around declaring and explaining their intent in this way. And what we also have in this case, the first ever live-streamed genocide, is hundreds and hundreds of videos of the Israeli officers and soldiers from Gaza who are mirroring then this language of intent on the leadership, on the political and military leadership level, right? on the ground, they're telling us constantly how they understand what they're doing, the genocide, in the language of the political and military leaders. Sometimes, and there's no time to go into it right now, but sometimes the language, right, they really use language that, say, Netanyahu had used just a couple of days before a certain video of an Israeli soldier and officer, right? So they're paying attention. They are telling us that they understand the political and military leadership, what they're saying as it is intended, in this case, to destroy Palestinians in Gaza as such. Now, it's important to say in relation to this, the question is, why do we see it in this case in this way, right? Why is Israel, as I've described it, a textbook case of genocide in this way? And the reason, of course, is that Israeli Jews, the Israeli state, is imagining that they are fighting a colonial war against barbarians, quote unquote. This actually goes back to the origins of international law that were meant to regulate wars between civilized nations, Europeans, not to regulate Europeans putting down colonial rebellions. And that's how Israeli Jews, they are telling us that this is actually a settler colonial war. This is a colonial war against barbarians, against human animals, against Nazis. Israeli Jews and the Israeli state imagines itself outside of the realm of law, and definitely outside of the realm of international, and therefore they can say and do whatever they want with impunity, right? And we've seen this. This is the reason that we're seeing what we're seeing for 23 months unfolding now. This is the reason that Western states, including the UK government, are supporting this imagination of the colonial warfare, which is the reason that we see these expressions of intent to destroy. And it's important to say that if we take the journalist and writer who I quoted at the beginning, right, he is asking us, where is international law? Israel, the US government, Israel's supporters, including the UK government, what they want or what they're doing, the result of what they're doing is the complete destruction of international law. And that would be horrific. It is already horrific for Palestinians in Gaza, Palestinians in Palestine, throughout Palestine. It will be horrific for everyone in our world and in the world to come. And I think in this way also, Israel's genocide in Gaza and Palestine is really an issue that should be at the center of concern and attention for people around the world. Either we have international law, and we definitely need to change the system of international law that we have, but either we have it or we face a lawless world that looks like Israel's genocide in Gaza.
Thank you very much, Raz, for this important testimony. And if you have anything else that you would like to submit for the report, please do so in the coming days. Shahid?
Thank you so much.
We would like now to welcome Gerard O'Quinn, who's the founding director of the Global Legal Action Network, GLAN, where he is responsible for GLAN's legal actions and strategic growth. He's a professor at the Irish Centre for Human Rights and formerly lectured at Lancaster University Law School and was a visiting fellow at the Transnational Law Institute at King's College London. He was educated at the National University of Ireland, Galloway, University of Nottingham, where he also completed his doctorate, which was funded by the Wellcome Trust. His academic research focuses on public international human rights and public health governance. He has active links with legal professionals interested in new avenues in clinical legal education, especially within public international and the use of technologies in pro bono legal work. The floor is all yours. You are muted.
Thank you. Good afternoon. I am honoured to present to the Gaza Tribunal, and sorry I could not do so in person. My name is Gerard O'Quinn. I'm founding director of the Global Legal Action Network, and as you may have heard from my colleague Charlotte Andrews-Briscoe yesterday, together with our Palestinian partners, we have been challenging the decision to permit UK weapons exports to Israel since October 2023. During these protracted proceedings, the government, under threat of injunction, suspended export licenses for weapons being used in Gaza. However, they made an exception for the F-35 components, which are sold indirectly to Israel via the global spares pool. This was despite the International Court of Justice finding there is a plausible risk of genocide committed against Palestinians in Gaza. And today I would like to present to the Gaza Tribunal further insights from what we have learned about the role of the British government, namely the engineering of an accountability gap within the UK, a gap that shields not just weapons exports, but also legally problematic Israeli cooperation. I am to share with you the tactics which effectively renders the UK a participant in Israel's atrocities against the Palestinian people. As highlighted yesterday, our case exposed how the UK government, despite overwhelming evidence, has A, chosen to ignore blatant IHL violations, even claiming it has seen no evidence of deliberate targeting of women and children. B, it has withheld critical evidence, including a document on the sniping of children. C, it has used a wholly unfit methodology to assess Israel's compliance with international humanitarian law, IHL, and use this to make a determination that genocide is not occurring in Gaza. Effectively a methodology that is not fit for purpose and nor could appropriately be used to make such a determination. And together these tactics, which we saw unfold over the course of our case, have provided superficial legal cover for UK weapons exports, but also broader cooperation with Israel. So beyond the limited arms exports suspension that we saw committed to this time last year, it is clear that the UK has largely maintained military, economic and political cooperation with Israel and has not demonstrated a shift from its usual baseline. This inaction is indicative of a government that is not compliant with the UK's legal obligations, especially the duty to prevent genocide. In January 2024, the International Court of Justice concluded, as I said earlier, that there was a plausible case that genocide was being committed in Gaza. There is a legal consensus that the UK's duty to prevent genocide was crystallized at this point in respect of Israel's offensive in Gaza. This duty requires the UK to take all reasonably available measures within its power, which might contribute to the prevention of genocide. It has been referred to as the beating heart of the Genocide Convention, the legal expression of never again. This duty to prevent should have triggered the undertaking of a root and branch audit of the UK's relationship with Israel across multiple fronts, diplomatic, military and economic, to identify where there was potential complicity or leverage that could be addressed to prevent genocide. Our legal case argued that this fundamental obligation should not be superseded by contractual obligations with US weapons manufacturers who are producing Israel's warplane of choice. And I should note there are further non-assistance duties that emanate from Israel's serious breaches of important legal norms and the violations of the Geneva Conventions, which have consequences for the UK under international law. But for brevity, I will not explore those here. And recently in our case, the High Court determined that certain parts of our legal challenge were non-justiciable, meaning that they were not matters for the court, and that constitutionally the executive is democratically accountable to Parliament and the electorate. So this gives us pause to consider about what has unfolded in Parliament. My colleague explained yesterday what happened in court. And here, once again, we see concerted attempts to undermine transparency and accountability around the UK's cooperation with Israel. Parliamentarians have repeatedly asked for more information on how the UK is fulfilling its duty to prevent genocide, but they have effectively been derailed over many months. And this derailment has been achieved by the following tactics. First, ministers, when asked specifically for information on how Israel, on how the government is carrying out its duty to prevent genocide, are misdirected. they typically receive a stock answer that switches the focus to how a determination of genocide is made, rather than the steps that the UK government has already taken to offset or to prevent genocide occurring. And this is what it typically sounds like. The UK government's long-standing policy is that any formal determination as to whether genocide has occurred is a matter for a competent national or international court, such as the International Court of Justice, rather than for governments or non-judicial bodies. So think about this for a second. When asked about preventing genocide, the UK government's reply is that you must wait for a court to determine that it has already occurred. They are actively deploying a legal absurdity to sidestep requests for information on how the duty to prevent genocide is being discharged now. And yet simultaneously in court, government lawyers argued the very opposite. They said that such matters are not for the court to examine. And government lawyers revealed that they had actually conducted their own genocide assessment, finding that genocide is not being committed in Gaza through that deeply problematic methodology we explained yesterday. And it had to concoct this absurd methodology to generate this answer. The second tactic I want to share is how ministers revert to speaking about IHL assessments and the licenses, the arms licenses that were suspended in September of last year. So when asked explicitly about the duty to prevent genocide and what steps the government was taking, David Lammy on the 20th of May of this year said, "It falls to me to make serious decisions about the sale of arms where there might be or where there is a clear risk of a breach of humanitarian law. I took that quasi-judicial decision very soberly and seriously in September last year, and this has continued to be the position since." Note that Mr. Lammy implies that the duty to prevent genocide is restricted to arms sales and is made through an ill-suited IHL assessment. What should occur is a due diligence style assessment under the Geneva Convention. And this should not be limited to arms exports. It should include an audit of all relevant UK-Israeli links to determine how the UK could contribute to preventing genocide. The government has shown itself to be determined never to have this legal obligation materialise. The third tactic is quite straightforward. Ministers simply deny that genocide is occurring. Mr. Lammy has said that not enough people have been killed, and Prime Minister Starmer has said he does not use the term genocide with respect to Gaza, but has not explained why, nor has he explained what his understanding of genocide is. So in Parliament, the government has not even acknowledged its genocide assessment exists, the one that we exposed in court, never mind shared it. In the format of parliamentary questions and scrutiny, this means that repeated deflections and misdirections serve as a response. It has happened so frequently and consistently, it amounts to a purposeful tactic to avoid speaking about the fact that the UK has conducted its own assessment and to avoid having to share whether the risk of a genocide has been monitored and acted upon by the government. It means there is currently a massive accountability gap in the UK with respect to complicity in Israeli atrocities, where the court defers to Parliament and in turn the government short-circuits parliamentary scrutiny. So in conclusion, the government has now been exposed as being disingenuous in Parliament and in court. We have documented how a number of tactics have been intentionally deployed in both settings to create a merry-go-round of delay and inaction, which facilitates genocide by keeping Israeli warplanes supplied and UK-Israeli cooperation free from scrutiny. Reflecting on our case, an editorial piece in a well-known British newspaper said, "This is not just moral evasiveness, but tactical contradiction, designed to sustain arms sales and diplomatic cover." To this end, the government needs to be pressed to publish its legal advice on the duty to prevent genocide. It needs to share its analysis, and it needs to explain what concrete steps they are taking to discharge this extremely important duty. Thank you very much. I'm happy to take questions.
Could you explain, for the benefit of the audience and those watching, the strange way in which the British government argued opposite positions in Parliament and in court. So I'm not sure the whole world is fully aware of that.
Yes, so repeatedly, when parliamentarians ask for information on how the UK is upholding its duty to prevent or discharging its duty to prevent genocide. So this could take the form of an audit, due diligence to understand what forms of cooperation exist. It may expose that the UK is actively supplying components, for example, that are being used in that genocide, or it may reveal leverage that the UK could use, be it diplomatic, economic, or otherwise. So this is a very forward-looking obligation, which is based on action rather than result. So rather than revealing this, the government simply says, look, it's not for us to even determine if genocide is occurring. They switch to a completely different conversation and they say, this is for a court to decide. So they say, it's not for us, it's for courts. And the conversation ends. And in the parliamentary format, that's all we're left with. In court, the government said it isn't for the court or the judiciary to examine this. And that the government had in fact made its own assessment about genocide and used it to keep the court at arm's length and presented a methodology that gave legal cover to their assessment and allowed them to keep the court away from scrutinizing their actions. So literally at the same time, one thing has been said in Parliament and another thing has been said in court. There's duplicity.
Do you know of any other government that behaves like that?
I'm not aware, but I haven't looked into it in detail, so I wouldn't be an authority on other jurisdictions.
Thank you.
If I may ask also, as a lawyer, how would you compare the British court's engagement with this case in comparison to other cases that you have handled? Or Palestine-related cases in general? How do you feel the attitude has been?
It's difficult to make comparisons because each case turns on a different set of laws, policies, and procedures. So that comparative analysis is difficult and wouldn't get us much further in terms of understanding how we can address this complicity.
And would you say that, in general, the rule of law has been upheld in these cases?
I would say what we're seeing here by this concerted attempt by the government, this is an active, they're using their agency here to deploy these tactics in a very conscious and consistent manner. And what's happening through these tactics is that they're defeating scrutiny. They're undermining the rule of law because they're riding roughshod over really important legal obligations, not just the duty to prevent genocide. And they're doing it to facilitate cooperation with Israel and avoid the scrutiny that would jeopardize that cooperation. So what we're seeing is the gutting of the rule of law through these tactics, a complete disregard, and a complete disregard as well for both types of scrutiny, judicial and parliamentary. And unfortunately, it has deepened the complicity of the UK in Israel's atrocities against the Palestinian people.
Thank you.
Thank you very much. We now move on to the last witness for the day, and I want to welcome Tayyab Ali. Tayyab, thank you very much for waiting, and apologies for the delay you've had today. We've got a bit behind schedule today, but I think everyone would agree that the power of the testaments that we've had meant that we had to hear them through fully. I want to welcome Tayyab, who's here on behalf of the Palestinian community as a whole, I think it's fair to say. Well, why not? But also he's a solicitor at a very esteemed company, Bindmans, and he leads the international law team there on general crime and extradition, and has an enormous experience of human rights work and obviously of representing the Palestinian people and Palestinian community. Tayyab, thank you so much for coming. We look forward to hearing your testament.
Thank you. Members of the tribunal, thank you for inviting me to provide evidence. on the vital question, has Britain fulfilled its legal obligations in relation to the atrocities in Gaza? And I just want to start by giving an outline as to why I might be well placed to provide evidence on that. In 2009, I led a legal team with another lawyer where we applied for and obtained an arrest warrant for Zippy Livni in relation to war crimes, an allegation of war crimes perpetrated by the Israeli government in Gaza. Since that time, I've established and led an organization called the International Center of Justice for Palestinians. Since October the 7th, that organization has been involved in direct evidence gathering, which includes interviewing a significant number of individuals that were present in Gaza during the last couple of years, but also civilians that have left or been evacuated from Gaza, who suffered direct injuries as a result of Israel's attack. Our primary evidence is around 200 individual witnesses at present, and that evidence is gathered in a very specific way. It's video testimony gathered to a British criminal legal standard and has been submitted across Europe and various other legal and political institutions to give an indication of the evidential basis of what's happening on the ground in Gaza. And so to answer the question, has Britain fulfilled its legal obligations in relation to the atrocities in Gaza? I'm going to start with the answer and then explain the answer. The answer is a categorical no, it has not. Britain has not fulfilled its obligations in international law. Worse still, it's actively breached them through arms transfers, diplomatic shielding of Israel, obstruction of accountability, and the abandonment of its duty to protect the independence of international justice. So today I'll provide evidence on Britain's obligations that flow from just three sources: the Genocide Convention and the ICJ's provisional measures in South Africa versus Israel in January 2024, the ICJ's advisory opinion of July 2024 on Israel's unlawful occupation, and the Rome Statute and Britain's duties as a state party to the International Criminal Court. So turning first of all to the Genocide Convention and the ICJ provisional measures. In January 2024, I know members of the tribunal, you've heard extensive evidence about the ICJ rulings. But in January 2024, the ICJ found that allegations of genocide in Gaza were plausible. It ordered Israel to take specific action in order to prevent irreparable harm to the Palestinian people. At that moment, at that precise moment, every state, including Britain, had a binding duty to prevent genocide. And I want to just drive that point home because supporters of the Israeli action in Gaza, including, I would say, the president of the ICJ, who did an improper interview to explain that judgment, have recategorized that as something quite different. I'm going to make it plain. The only reason a court issues provisional orders is if it's trying to prevent something. And it only tries to prevent something if it thinks something is going to happen, or is happening, or is likely to happen. So whatever the commentary around the ICJ's provisional measures judgment in January 2024 is, something is really clear. The court thought that if Israel was not ordered to behave in a particular way, under the Genocide Convention, there would be irreparable harm to the Palestinian people. And I think where we are today, we're seeing that actually happen. So the court has been clear since its 2007 judgment in Bosnia versus Serbia. The obligation to prevent genocide arises the instant a state knows or should know of a serious risk. That duty requires states to abstain from providing military, financial, or political support. Articles 1 and 3 of the Genocide Convention prohibit perpetration, but also complicity. Britain ignored this. It maintained trade, intelligence, and military cooperation with Israel by licensing components for the F-35 fighter jets, which form the backbone of Israel's assault on Gaza. Britain has substantially facilitated international crimes and crossed into the territory of complicity. Now, let me turn to the ICJ's advisory opinion in July 2024. I want to say something about those words, advisory opinion, because again, people that support Israel's action in Gaza refer to an advisory opinion as advice you can take or advice you can leave. That's not correct. What an advisory opinion means when the ICJ is asked to provide one is to determine the settled position in international law about a situation. It's advising on what that position is, and that position is binding on all member states, all parties to the ICJ, all parties to the United Nations. So it's not an advisory opinion in the sense that you can take the advice or leave the advice. It's an advisory opinion telling you what your obligations are. And that's an important context on that. Well, in July 2024, the ICJ issued a historic advisory opinion. It ruled that Israel's presence in the occupied Palestinian territory, which it determined as Gaza, the West Bank and East Jerusalem, is unlawful and must end immediately. The court found that Israel's conduct violates the prohibition on racial segregation and apartheid under international law and breaches the Palestinian people's right to self-determination. These are called erga omnes rights, owed to all of humanity. That means that every state has a legal obligation to act, not simply a moral choice. The court laid out specific duties for these states. Do not recognize or assist Israel's unlawful presence. Abstain from trade or investment that entrenches the occupation. Prevent companies or charities from aiding the settlement enterprise. Ensure diplomatic practice does not legitimize illegality. Britain has failed on every single count. In September 2024, it suspended just 30 out of roughly 350 arms export licenses while continuing to authorize critical F-35 components. And you've heard from Gerard the somersaults and acrobats that the British government has done to maintain that, in my view, grossly unlawful position. British surveillance aircraft have flown missions over Gaza with no transparency as to whether the intelligence has been shared with Israel rather than the ICC. British Petroleum has continued to supply crude oil to Israel, likely refined into jet fuel for attacks in Gaza. Britain still allows illegal settlement produce into UK markets, despite acknowledging that settlements are unlawful. And when the UN General Assembly voted in September 2024 to adopt the ICJ's findings, Britain abstained. An insight into the psychology of the British government. And now I'll turn to the obligations in relation to the ICC. The ICC, the International Criminal Court, is the central accountability mechanism for crimes in Palestine. As a state party, Britain is bound by Article 86 of the Rome Statute to cooperate fully, and by Article 89 to execute arrest warrants. Yet Britain has undermined the court. I'm going to say that again. Britain, as a state party to the Rome Statute, has undermined the court. It has questioned its jurisdiction, withheld support for arrest warrants, and failed to facilitate investigations. Worse still, Britain stood by while the ICC prosecutor Karim Khan, who is a British citizen, came under unprecedented attack. He was subjected to United States sanctions, not only personally, but against members of his family. His bank accounts in the UK were closed. Now, I'm going to just make a point about that. He has had no formal or unofficial or official support from the British government with regard to the United States sanctions on him. His bank accounts remained closed by a British bank. Now, also, with over 30 years of an unblemished career, the prosecutor is suddenly subject to misconduct allegations which have paralyzed his office. In Breitbart interview on the 27th of August, 2025, Prime Minister Netanyahu directly revealed that he apparently had more knowledge of complaints about Mr. Khan than Mr. Khan knew about himself, providing strong evidence that Israel has interfered in the core of the misconduct proceedings. At worst, it appears that Israel is supplying complainants to the UN oversight body and commentating to the public on matters that are simply not true in order to influence the decision makers at the Assembly of State Parties, including the United Kingdom. And the investigators, but most importantly, destroy the prosecutor's reputation in the public domain. Reports in Le Monde and Middle East Eye have also reported that David Cameron, as Foreign Secretary during his time in government, directly threatened the prosecutor in relation to the Palestine investigation. Now, if this is proven, it would amount to direct state interference in judicial independence, a flagrant breach of Britain's obligations under the Rome Statute. By refusing to defend the prosecutor, condemn sanctions, or shield the court from interference, Britain has not only betrayed the victims of Gaza, but actively undermined the very institution designed to deliver justice. Britain's obligations do not end with these three sources. They are reinforced by a wider body of binding international and domestic law. Under the Geneva Conventions, to which Britain is a high contracting party, the UK must respect and ensure respect for international humanitarian law in all circumstances. That means it cannot turn a blind eye to grave breaches committed by others, nor provide material support that would enable them. Customary international law also imposes duties on all states not to recognize or assist serious breaches of peremptory norms, such as genocide, apartheid, or unlawful occupation. Britain is further bound by the Arms Trade Treaty, which prohibits the transfer of weapons where there is a clear risk they will be used to commit genocide, war crimes, or crimes against humanity. Just on that point, Lush cosmetic stores recently carried out a day's strike because it was able to make an assessment that there were serious war crimes being committed in Gaza. I would seriously recommend the British government hire Lush's lawyers to get some proper legal advice, because currently their lawyers are failing them. As party to the European Convention on Human Rights, the UK must avoid contributing to violations of the right to life and the prohibition of torture, even where its actions have extraterritorial effect. And the UN Charter of the UK has a positive duty to uphold the right of people's self-determination and to comply with binding decisions of the Security Council. And finally, Britain's own domestic legislation, including International Criminal Court Act 2001 and export control laws, requires it to criminalize and prevent grave international crimes and to deny arms transfers where there's a real risk of misuse. Taken together, these instruments make clear that the UK cannot remain neutral or passive. It must act to prevent, punish, and refrain from assisting violations of international law. So this failure is a choice. It's not a matter of capacity, it's a choice. A potentially criminal weakness in the UK's adherence to principles of international domestic law. It's a clear failure of political will. Britain acted differently in the Ukraine situation. It swiftly imposed sanctions, suspended trade, armed the victim, and fully supported the ICC. In Palestine, Britain armed the aggressor, shielded it from accountability, and obstructed justice. When Jeremy Corbyn, chair of the panel, introduced a bill calling for an inquiry into UK complicity, the government rejected it outright. That was a demonstration of a lack of neutrality. It was a decision to suppress scrutiny and preserve impunity. The consequences are severe and far-reaching. For Palestinians, Britain's weapons trade, silence have contributed directly to their suffering and death. Every bomb that falls on Gaza carries with it the shadow of British complicity. For international law, Britain's selectivity reduces genocide and the Genocide Conventions to instruments of convenience, stripping them of universality. For accountability, by failing to condemn US sanctions on Karim Khan, a British citizen, by ignoring the targeting of his family, and by itself engaging in political interference, Britain has emboldened those who seek to dismantle international justice altogether. For Britain itself, ministers and officials who authorized unlawful exports, obstructed accountability, risk exposure under universal jurisdiction for themselves. Complicity in genocide cannot be forgotten. It should be prosecuted. And I want to close, if you like, with 12 points. To meet its obligations under the Genocide Convention, the ICJ's rulings, and the Rome Statute, what should Britain have done? One, it should have imposed a total arms embargo the moment the ICJ found a plausible risk of genocide, including halting all arms exports, dual-use items, and surveillance technologies. Two, ended all surveillance flights and intelligence cooperation with Israel, unless intelligence was being shared with the ICC for accountability purposes. Three, suspended military intelligence and political links with Israel in their entirety, including training, joint operations, and security cooperation, and certainly not inviting the President of Israel to the UK, as appears to be happening next week. Four, suspended its trade agreement with Israel and imposed a ban on all settlement products and services, rather than allowing them to reach British consumers. Five, regulated and penalized companies and charities complicit in Israel's unlawful occupation, including investigating UK-registered charities raising funds for Israeli military units or settlements. 6, issued wide-reaching targeted sanctions against senior members of the Israeli political and military establishment responsible for the assault on Gaza and for maintaining the unlawful occupation. 7, there's only 12, I'm coming to the end of the list. 7, prevented British citizens from travelling to Israel to join the IDF or participate in military operations in line with obligations under counterterrorism and war crimes legislation. 8, investigated and, where evidence permits, prosecuted British citizens who have served in the IDF and participated in alleged war crimes in Gaza or the occupied territories under the principles of universal jurisdiction. 9, defended the independence of the ICC prosecutor, condemning sanctions against him and his family and providing financial and diplomatic support to protect the court from political interference. 10, supported UN General Assembly and Security Council processes to enforce the ICJ's advisory opinion, including sanctions, suspension of Israel's UN privileges and accountability measures. 11, expanded humanitarian support for Gaza, restoring and increasing and protecting UNRWA and ensuring unimpeded humanitarian access rather than cutting funds at the height of the crisis. And 12, led international efforts to enforce accountability, including pushing for the execution of ICC arrest warrants and mobilizing like-minded states to isolate those obstructing justice. Instead, Britain has done precisely the opposite, supplying arms, providing political cover, cutting humanitarian aid, and even undermining the very institutions designed to deliver accountability. So in conclusion, I return to the tribunal's central question. Has Britain fulfilled its legal obligations? The answer is no. Britain has not fulfilled them. Britain has breached them. Britain has chosen complicity over prevention, political expediency over legal duty, and silence over justice. The people of Britain deserve the truth. The people of Palestine deserve justice, and history will judge harshly those who have stood by, or worse, armed and enabled and shielded the genocide. The tribunal is therefore not only an act of truth-telling, it's an act of accountability in the face of Britain's profound legal and moral failure. Thank you.
Taib, thank you very, very much for that very powerful and very comprehensive statement. Do either of my colleagues have questions?
Yes. Regarding your 12 points in the end, I know that you've been working on a few of these points in terms of actual trying to bring justice in the UK system. Can you tell us maybe a bit about one or two of these cases and what kind of response have you received from the UK security forces and from the UK legal establishment?
So we have submitted a number of complaints to Scotland Yard in relation to war crimes. I think most significantly, giving a little bit of preamble, if you recall me saying in my evidence, we applied for an arrest warrant in 2009 for Tzipi Livni, the former foreign minister, and we were granted that arrest warrant. What happened after that were a series of steps by political actors to prevent an actual arrest. So at the time, the police and the Crown Prosecution Service were very interested and proactively assisting in bringing Tzipi Livni to some form of accountability through a prosecution. The mistake we made was when Tzipi Livni was protected by British politicians, one in first instance by changing the law to allow the Director of Public Prosecutions, the Attorney General, to interfere with the arrest warrant process and the prosecution process by having to gain their consent before we apply for these types of arrest warrants in the future. The mistake we made was not recognizing at that time that political act was complicity in war crimes by safeguarding, protecting, aiding, and abetting potential future war criminals or even war criminals at that time. And that's something that's informed our legal work at the International Centre of Justice for Palestinians since then. And so one of the first complaints we submitted to Scotland Yard was a complaint against 5 British officials and ministers from the previous Conservative government, where we have alleged complicity in the crime of starvation with regards to Israel's actions in Gaza. Now, that that complaint is fueled by the evidence that I've explained in my submission, and also very good expert evidence from a series of experts. Now, Scotland Yard is currently engaging in what we call a scoping exercise with regards to that. So what they're trying to do is determine whether within that complaint they should proceed to a prosecution or not. And I'll be frank about it, my patience is running very thin with Scotland Yard, because if they do not proceed to do their job, which is to analyse that information and evidence and initiate arrests for those ministers, we will then move to a second stage, which is to apply for private arrest warrants with respect to those same individuals. We have got 2 other tracks which are coming live very soon, but I'm going to speak about them in a very brief way because I don't want to prejudice the applications. One is with regards to British citizens that we think have, or we consider have violated British domestic legislation by travelling to Israel and joining the IDF, not to commit a war crime, but simply by breaching something that's called the Foreign Enlistment Act in the UK. And there is a significant number of individuals currently under investigation by us with regards to that. And that will be the subject of private arrest warrant applications imminently. And then there's a separate track of British citizens that we are aware of that have joined the Israeli Defense Forces and are currently present in the United Kingdom, but where we have sufficient evidence to bring a criminal private arrest warrant complaint with regards to those individuals. And those applications are being prepared as well. Now, it's separate to that, there is a process you've heard about by other evidence with regards to the Hague Group, for example, is series of accountability efforts across the globe that are currently occurring in different jurisdictions to bring people to account. And so the ICJP has also launched something called Global 195, which is a global project to bring accountability in domestic jurisdictions across the globe. And what we're finding in that, and I have to be careful about what I say about that, is real interest from police forces across the globe in accountability mechanisms. And in fact, that interest is manifesting in a mechanism where we are now being approached by police forces from some jurisdictions. Interestingly, also some Western jurisdictions that are asking us to provide them with evidence because they are investigating potential violations of international humanitarian law by their own citizens in their states. And I can see a behind-the-scenes momentum increasing. The problem, of course, is Britain's cowardice to stand up to the United States implementation of sanctions for people that are engaging in these accountability exercises. And we've seen just recently Al-Haq, Al-Mazan, and another organization in PCHR being sanctioned for this exact accountability work. And that's something that is that the United Kingdom needs to address directly. I feel it won't, but it needs to.
So do you think that there is also a place for personal culpability for Stammer, Lammy, Sunak, and the rest of the people that have been leading this complicity you've been discussing?
Well, I can tell you this. That we submitted, first of all, letters to politicians in all parties that supporting Israel and Israeli war crimes would potentially render them accountable under the Rome Statute for complicity, aiding and abetting, providing material support, including political cover. We issued the complaint against the Conservative ministers whilst they were in office. And we continue to pursue that track. I will say to you that the activities of the current government is actively under investigation by my organization and my investigators, which has included former police officers and currently includes a former senior district Crown prosecutor who's joined my team full-time, Crown Prosecution Service, former prosecutor. If we get to a position where we feel that we have sufficient evidence to bring criminal complaints against those that are currently in office, we will bring those complaints against those individuals. At present, we're watching very carefully as to what they will do with the complaints that are currently with the Crown Prosecution Service. Sorry, my mistake, currently with the police. But that does not mean that the current group of politicians that I think are probably coming very close to a criminal complaint will keep them safe. I think that's the way I want to describe it at the moment. I think that the things that I've outlined, the things that Gerard outlined as well in the previous submission, potentially cause British government ministers, including Keir Starmer, David Lammy, the defence minister, the foreign minister, David Lammy, the foreign minister, potentially even the Home Secretary, liable of complicity in criminal acts and subject to potential investigation. I think they're very close to that line. And I wouldn't be surprised if... what I will say to you, I think it's safe to say this, and I am hesitating a little bit because I don't want to prejudice my own work. If we find there is evidence of these people committing or aiding and abetting war crimes, just the fact that they've left office will not have them rendered safe. We will continue to pursue them in the same way as those Conservative ministers, some of whom have left office. Well, obviously they've all left office because they're not ministers anymore, but also left government or the Parliament are not safe because they still continue to be under investigation. I think that's the safest way for me to put this. But having said that, you know, this is not really my job, right? This is the job of the British police, who are meant to act independently of government, to hold government accountable, and also the International Criminal Court. And the International Criminal Court should be pressurized, supported, in opening files in respect of Western politicians that are supporting war crimes in Gaza. It's not really the job of civilian organizations, although it's very good that civilian organizations across the globe are doing the job of political and legal institutions and governments where they're failing to do that. And it's really heartening to hear the testimony from Ghislaine Long with regard to the hate group that governments are actually mobilizing in this way too.
Taib, thank you very, very much for that very, very powerful statement you've given us today. As with all other witnesses that have given evidence, I assume you'll be able to follow it up by sending us a copy of your statement so we can include that in our documentation.
Absolutely.
That now concludes the hearing of evidence. The three of us are each going to give a brief statement of where we're going from here and what our initial thoughts are. And so we'll start with that. Now, who's going up first?
Should I go up there?
Yeah. We're going to do it up from the rostrum, yeah.
I want to begin by thanking Jeremy and his team, Arten and Ali and Laura and everyone around him, for organizing this tribunal. As someone that has been following what has been going on since October 7th, I have still learned a great deal during these 2 days. And I'll just say a few things. So the tribunal began with wrenching testimonies from and about Gaza, about the mass assassination of civilians alongside the systematic attacks on Palestinian healthcare system, which is responsible for saving and sustaining the life in the Gaza Strip. We have heard testimonies of doctors who have treated children whose bodies were burned, whose limbs were detached, and whose faces were scorched. We have learned how they had to do so without the necessary medical equipment and even without painkillers, and how screams of men, women, and children continue to haunt them till this day. We have heard of cancer patients and dialysis patients dying because they cannot get treatment. We have heard about famine, how Israel is depriving Palestinians of objects indispensable for their survival, how mothers and fathers search for food for their hungry children, and how often they go to sleep hungry. We have heard of babies dying because Israel prohibits the entry of formula. We have heard the different pattern of wounds and injuries sustained by hungry boys and girls lining up for food at the gates of the Gaza Humanitarian Foundation. We have heard of children dreaming, having a clean cup of water. We have heard how men aged 15 to 70 are considered killable, regardless of who they are. We have heard how healthcare workers have been assassinated at a much higher rate than civilians, and how their families have also been targeted. We have heard how Israel has denied access to journalists and then began a killing spree of Palestinian journalists, killing one after the other after the other. We have heard how the Israeli military has categorized 86% of the Gaza Strip as a military zone, pushing the civilian population to what is considered a humanitarian zone. We have heard how Palestinians have been killed on the way to these zones and often within them. We have heard about that 90% of Gaza's population has been displaced, most of the people many times, and many of them more than 10 times. We have heard that there is no safe space in Gaza. We have heard how Israel's destroyed almost every school in the Gaza Strip and practically all of the universities. We have heard how children have been denied access to education. We have heard how the biosphere of genocide that Israel is creating and how the harm that Israel is generating in the Gaza Strip is actually much more extensive than is currently known, and how it will affect the Gaza Strip for decades, if not generations to come. We have heard from lawyers and genocide experts. We have heard how Israel's violated the most fundamental principles and clauses of international humanitarian law, the principle of distinction and the principle of proportionality, how the Israeli military has violated the prohibitions of attacking medical units and education facilities. We have heard that the occupation itself is illegal, and not only the conduct within it. We have heard that British citizens who are living in the West Bank and serving in the Israeli military in Gaza are in violation of international law and, legally speaking, should be arrested when re-entering the UK. We have heard about the UK government's line of defense, about the claim made by UK politicians that Israel's intentions are not clear and therefore it is not obvious that military has violated international law. Witnesses have highlighted Israel's intention, which are not really a secret. They have emphasized that intentions can not only be deduced from statements, but from the patterns of the actions, and that the patterns are very clear. The patterns are genocidal. That witnesses showed in other words that the UK government's claim about intention is nothing more than a ploy, and that there is no doubt that every single day for almost 2 years now, Israel has been committing egregious violations of international law. We have heard that even members of the Labour Party have not received access to reports made by the UK legal department, so it is not clear whether these are the claims made by UK legal experts or whether what we're being hearing are the politicians that are trying to cover up crimes. Genocide experts have also appeared before us, explaining how Israel's actions meet the definition of genocide and how there is no doubt about this in the international scholarly community, and that indeed only partisan supporters of Israel think otherwise today. We have heard that one of the lessons of the Holocaust is that if we want to understand genocide, we need to listen to those who underwent and experienced genocide and not to the powerful states that committed it. We know that the UK government is listening to Israel. We know that the UK government has not opened its doors to the Palestinians, British citizens of the UK, or citizens of the UK that want to testify what has been going on to their brethren, but the doors are locked to them, but open to the Israelis. We have also heard that genocide is carried out through genocide denial. The fact that the UK government has opened lines of communications with Israel, but is unwilling to speak to Palestinians, says a great deal. We have heard how despite its legal obligations, the UK government has not acted in due diligence, has not stopped the transfer of F-35 parts manufactured in the UK, and how it has been supporting Israeli military operations through surveillance flights from military bases in Cyprus. We have heard how the UK has been supporting Israel in an array of diplomatic fora about the significance of this support for the continuance of the genocide. Ultimately, we have heard about how a politics of deception has taken over the UK government in all of its handling of Israel and the genocide Israel is perpetrating in Gaza. We have heard that this politics of deception is produced through the circulation of misleading information, half-truth, disingenuous responses, and lies that are designed to cover up crimes. We have learned that it is bolstered through the cooperation of the Israeli and UK intelligence communities, through pressures of corporations that profit from war making, through different lobbying groups, and through politicians working at their behest. We will now have to examine the evidence put before us and write a report that will be presented to the UK government and Parliament. The efforts to cover up UK involvement will no doubt continue. But despite all these efforts, I'm confident that the truth will be revealed and justice will ultimately prevail. Thank you.
I start by thanking all those who have put in efforts to make this day a reality, as well as all the witnesses who came here and generously gave us their time and expertise. And again, we started this with a heavy heart and we end this with an even heavier heart. In the past 2 days, as I listened to the witness statements, I couldn't help but remember how it's like when I teach my students in critical introduction to law and ask them, how does atrocity happen? And what is your job as a lawyer to prevent it? How do we understand a system that normalizes the mass killing of people, the dehumanization of them? How do we normalize a system that favors profit, military-industrial complex, racial supremacy, over basic humanity? Whenever I confront my students with the history of mass atrocity, they feel as if this was in the past. Whenever we talk about what England has done in Kenya, what it's done in India, what Germany has done to its own people, as well as to the Herero and Nama people in Namibia, what the Italians have done to the Libyans, and the list goes on. What the Americans have done to the Native Americans, what the Australians have done to the Native Australians. And it's a history of mass slaughter. It is always a shock to me that I receive students at the age of 18 who have no clue about this history. That is what we call colonial erasure. That is what we call the normalization of atrocity and the normalization of a world system that is premised on exploitation, subjugation, and domination. We live in a world that says that we do have laws. In England, we say that this country abides by international law. We hold dearly to the UN Charter. And yet, we forget that there's a twist there. And there's a twist of absolute hypocrisy that is a bit different from the past. There was no international law in the past. It was simply scholars explaining it to each other. There was no television, and there were no history books studied by the masses. But now we see it in front of us. How do you commit a live-stream genocide and still uphold the civilizing narrative to say that you have the upper hand? That actually, no, we didn't commit anything wrong. This was all just fine. We can walk in the streets of Westminster and say that they are the barbarians, not us. We are the civilized and they are not. Our witnesses have drawn to us a portrait of how is it that you can design complicity and still say it with a straight face. The context of extremity sheds power relations bare. We heard horrifying testimonies from journalists, doctors, aid workers, political actors, confirming and affirming the worst that we could ever imagine. Accounts that bring to mind untold sorrow, things that we only thought exist in epics. Perhaps even Baudrillard was true in saying that it does feel as if it's a bit of it's a spectacle. It's a little bit real, but not exactly real. None of us could really comprehend and really conceptualize exactly what we're talking about. What is the visceral blood that is running? The fact that there's actual rivers of blood in the streets of Gaza, and the fact that even if causality might be a bit indirect, it's still causality nevertheless. Even if it is signing a paper that facilitates the licensing of a weapon, or a signing of a paper that allows the use of a military base, even though that might not seem like such a bloody act, it indeed is. It just requires a little bit of a stretch of imagination to imagine men in suits with blood on their hands. Our witnesses affirmed that the British government indeed has the knowledge and the capacity to understand and comprehend the reality on the ground. They even affirmed to us that the British government is undertaking surveillance flights that support that ongoing genocide. They have affirmed to us that they have information that is connected through the most advanced forms of intelligence, and yet persist to deny that. They have affirmed to us that the government does not share the information that it has with the public. We have heard of the legal premises of British states' obligations, and we have also heard how the British states ensured, through what has been described as acrobatic forms of tactic and engagement, to ensure that the law does not take its way. It was affirmed to us that the UK provides weapons, munitions, mines to Israel, military bases, surveillance flights. It was even affirmed to us that Britain hires, through its own taxpayers' money, private military contractors to assert with that. Tactics of delay, intimidation, contradiction of statements, politicization of legal proceedings, civil servants under intimidation and put in a position where they are condemned if they speak. These are the questions that I'd asked my students. What is the position of a civil servant that knowingly can see in front of them the complicity of their own government and is at the risk of losing their livelihood if they dare say a word? The British government hasn't only denied the British people's right not to be complicit in a genocide, it has also denied its civil servants the capacity to engage and apply the law. The actors of the British states, as well as corporations, seem to have forgotten basic history. Basic history that tells us that the truth of atrocity will come. It's either that they hope that the truth of atrocity will come too late, or that it will never come. Our job here today is to ensure that that truth comes in the present. Our job here today is to ensure that accountability doesn't arrive far too late. We have seen this evidence, and we have seen the blood on their hands, and accountability is coming. We will be examining the witness reports in front of us, and we've also given the world, we've given history, a repository of how British complicity has been designed, of how in open space, in front of a live stream genocide, you can deny reality, you can deny causality, and you can deny the law. This is a masterpiece of war crimes, a masterpiece of a joint criminal enterprise. I thank you all for coming here today. I thank you all for standing witness to this historical moment. And I hope that you'll also read carefully the outcomes of this tribunal. And we hope that today we've come a step closer to an inevitable moment of reckoning of the most atrocious things that we've witnessed in our lifetimes. Thank you.
Thank you very much. First, I want to say a big thank you to my colleagues, Neva Gordon and Shahid Hamouri, for being with me for the past 2 days, listening to all the testaments that have been put forward, and we will obviously be working very closely together to put together a very comprehensive report. I want to say an enormous thank you to the 29 witnesses that we've heard over the past 2 days. To each and every one of them, your evidence and your testimony has been invaluable. You've revealed the hidden truths on so many things that we've been told by the mainstream media and indeed by our government. You've helped to expose the truths, and we will obviously amplify that. And you're paving the way for a path for justice and accountability. I want to say a particular thank you to the Palestinian speakers that have been with us in the past 2 days. It's very difficult for them. They all have family, they all have friends, and they all know that their families and friends are suffering in Gaza, in the West Bank, in the Jordan Valley, and indeed, in some cases, in the refugee camps in the surrounding area. And they feel a sense of security in being out of the fighting that's going on in Gaza, but they also feel that sense of a need to be there, to belong and be with their families and their friends. So I think we should just hold our hands and our heart out to all of the Palestinians that have made such an enormous contribution over the past 2 days. And none of this tribunal would have been possible without the work done by our team in the Peace and Justice Project, who put this together after I put forward the private member's bill in Parliament calling for an inquiry. So I want to say a huge thank you to all of the team at the PJP and all of the volunteers that have come here for the past 2 days. They've done an absolutely magnificent job in making sure that this tribunal happened, and it's now up to all of us to take it a little bit further forward. We've heard the most horrendous stories of the position that doctors, medical workers and aid workers are placed in, and I just cannot begin to think what it must be like as a doctor to be operating on a child without anesthetic, without even any means of cleaning the wound, and just trying to save that life. And if the child survives, the horror that that child has been through will never leave them. The unbelievable levels of pain of an operation without any anesthetic. And then in some cases, as we were told, the child or the patient, if it's an adult as well, dying because of there's not enough food, there's not enough water, there's not any way of them surviving. And none of that is some act of nature. None of that is some random event. This is a calculated decision by the Israeli Defense Force and the Israeli government to deny food, deny water, deny medicine, deny support, deny the opportunity to survive for those that have been injured by the bombs that have fallen. And we've heard about the food shortage and the horrendous way in which life goes on in Gaza, or people try to survive. Just imagine you're suddenly in a society where the food imports don't come, the prices go absolutely through the roof on every single thing. And talking with people from Palestine outside of this inquiry today, people telling me that things as simple as an onion are on sale for £10, and that if you have some money, foreign currency, and you need to change it, the money changer takes half of the money as a commission. And that is what happens in a society where everything breaks down and people are just trying to survive. And those young people who've lost their siblings, lost their mum, lost their dad, lost their aunties, uncles, the whole wider family will live forever with the survivor's guilt of just still being alive. And so you then start looking, why has all this happened? And we've been through the issues of the decisions made by the International Court of Justice and the International Criminal Court, which have given a very strong decision and a very strong ruling. And as we heard from Tayyab Ali in the last evidence put forward, when the ICJ and the ICC make a decision, that decision is binding on every single member state that is either associated with the ICJ or the ICC or both. Britain is associated with both, therefore has a requirement to fulfill the obligations of those judgments. The whole point of our inquiry, the whole point of my private member's bill was to influence the British political process, to ensure that the decisions made are actually within international law and that we put ourselves on what I would call the right side of history. So it now falls to us to produce a report based on the evidence we've picked up over the last 2 days, and any further evidence that comes in very quickly, please, in the next few days, because I recognise that there wasn't a great deal in the evidence about the environmental situation or sustainability of life on the Gaza Strip. It came to some extent in the Isle Weitzman's evidence this morning, but I think we could do with some more about that. But in my bill to Parliament, I asked for an independent public inquiry. The government refused it and said they didn't want one. Okay? So I said, right, if you don't want one, we'll do one anyway. That's why we've held it here for the past 2 days. And so we will then be presenting our evidence to all the appropriate people. When the report is finalised, we will take it to the Foreign Office. We will ask for a meeting with David Lammy and others and present the findings to them. I will also present the findings to Parliament, and I'd be grateful if all of those that are watching this, please use the report when it comes out to further the cause of peace, to further the cause of justice, and to try and alleviate the horror story and the suffering that the Palestinian people have been through. Over my lifetime, it's been my privilege to go to Palestine on 9 different occasions. I've been in all parts of Palestine. I've had some wonderful meetings with some wonderful people. I've heard some horror stories, but I've always been impressed by the fortitude, the culture, the determination, and the civilization of the Palestinian people, their poetry, their music, their art, and everything else. And I've never forgotten going to primary schools in Jalabia refugee camp, talking to the children there, them reading the poetry they'd written. That school is destroyed. Many of those children will now be dead, and the hopes that they had for a life of peace, for a life where they could fulfill their ambitions, sadly gone for those that have not survived. And so we say to all of those our support and our solidarity. But we must not just be bystanders and witnesses of what has gone on. We have to be able to do something about it. That's why people march, that's why people meet, that's why people demonstrate, that's why people take legal action, and that's what we've done today, is to try and expose the truth on all these issues, to bring to bear expert knowledge, to bring to bear principles of how we can help to alleviate the appalling suffering of the Palestinian people. If we're bystanders to the horror show of the genocide that's going on, then in effect, we're doing nothing about it. It almost makes us complicit. None of us here are complicit. None of us here are bystanders. All of us here are involved and activists. We will take this forward. We will demand the truth, and we will always support the Palestinian people through the horror story they're going through. The arms trade must stop. The sanctions should be imposed. The ICC and the ICJ should be observed and respected, as indeed should the decision made by the United Nations General Assembly. Our inquiry over the past 2 days is done with minimal resources and a great deal of enthusiastic volunteer help. We need something bigger, we need something stronger, and we will be demanding that, and we'll keep on demanding that until justice prevails and the Palestinian people are able to live free from occupation and not be treated as the potential for being some kind of resort area on a Mediterranean beach. It's the home of the Palestinian people, and long may it be so. Thank you.